everyone hear me and presumably see me? No? If you can't quite hear me, I think there is some work on the audio. But if you do want to come a little bit forward, so that you can hear, in the meantime, that probably would be helpful.
Could you turn the hearing loop up a little bit?
Yes, please. Can I just? Yes, turn the hearing loop up for me. So if you can just tell me if there's any issues, and we'll try and sort that out.
Thank you.
Okay, my name is Gareth Bargus. I'm the Planning Inspector, and I've been appointed by the Secretary of State to hold this inquiry into an appeal made by Wayne Homes North West Limited under Section 78 of the Town and Country Planning Act 1990 against the refusal by High Peak Borough Council of an application for full planning permission for residential development comprising 92 dwellings, including areas of public open space, landscaping and associated works at land to the south of Dinting Vale, Glossop, SK13 6NY. Before we start, I do have some procedural and administrative matters to deal with. Firstly, housekeeping matters. Can everyone switch off their mobile phones and set them to silent, please? I'll just give people a moment. If anyone's got notification settings on their emails, that also would be helpful if you could just turn them off as well, please. Okay. Can a representative of the council just please run through the examination, the emergency evacuation procedures for me, please, and the assembly points in the event of a fire, and also confirm whether any fire drills are planned?
Yes, sir. Good morning. There is no fire drill or other emergency drill planned. In the event that we hear an alarm, we follow the green exit signs. I'm going to be going out of that door because that's the closest, and then turn left and we congregate on the car park.
Thank you. And then just to remind people, for the purposes of fire, there is an attendance sheet if people haven't signed it, if they can sign themselves in. That's just a record for if we do have to marshal and leave, so to check everyone has evacuated the building. There is also a separate sheet as you enter on the table. That's for your car park registration. You need to put your car parking registration in there to avoid any parking issues. Okay. Now moving on to the appearances. For certainty, can I now have the names of the people and any qualifications they wish to be recorded, who will be actively involved in the inquiry throughout, including later sessions on conditions and obligations? And I'll start with the representatives of the appellant, please.
Thank you. Good morning, sir. I'm going to hand out at this point a sheet containing the appearance list, and I might as well ask Mr. Mellon to distribute my opening, which I propose to be giving shortly.
Thank you. Has this been shared with the council?
Yes.
Yes.
My learned friend has gone.
Okay. So I'll accept the appearances sheet as inquiry document 1.
Yes. So good morning. My name is John Barrett. I'm of counsel, that is a barrister. I'm instructed by Niall Mellon, who's a chartered town planner and an associate director with Hourigan Planning, whose offices are in central Manchester. So I propose to call a number of witnesses. My first witness will be David Roberts, who deals with highway design and safety. Then followed by Richard Nicholas, who deals with engineering and access from the A57. Elizabeth Whittall deals with air quality. Rachel Kerr deals with ecology. Ian Tavendale, arboriculture, trees, etc. Richard Heathcote deals with viability. And finally, Mark Hourigan deals with planning policy and the planning balance.
Thank you. just to confirm, I've accepted your opening as inquiry document 2 as well, so we've got indirect inquiry documents 1 and 2. Thank you, Mr. Barrett. I'll move on to the council, please.
So, good morning. My name is Hugh Richards. I too am of counsel, that is to say, I am a barrister. I am instructed by Legal Services at High Peak Borough Council. Sitting to my left is Mr. Bruce O'Brien, and to his left, Ms. Nicola de Bruin, and they will be assisting me at the conditions and round table session.
Thank you. Is there anyone else who wishes to say something during the inquiry? Thank you. Firstly, I'll need to know your name and your address and who you're representing. If it's anyone other than yourself or a group, and if you have the authority to do so, whether you support or object to the proposed developments and any qualifications that you wish to record. I assume you'll be happy to answer questions when you give evidence. That includes from parties and myself. Yes. You should note that if you speak, give evidence or ask questions during the inquiry, your name will be listed on the decision letter. So if I can just take a record now, I'll start from the left, from those who wish to speak. I will invite you in at the appropriate time. It'll be after the first break with the openings. If it's on highways, I think there's a separate session to discuss other matters tomorrow. Okay.
My name is Stuart Gardner. I'm a councillor for Symondley, which obviously falls where this proposed site is. I'm against this proposal.
Councillor Gardner.
Yeah, my name's Paul Hardy. I'm High Peak Borough Councillor for Old Glossop. I've lived in Symondley for 45 years, so obviously I've got an interest in this. But I also would like to speak for Councillor Elliot Starkey, who is the Councillor for Dinting and Governor at Dinting Primary School, who is actually in work this week and can't be here.
Thank you, Mr. Hardy.
David Bennett, that's B-E-N-E-T-T. I'm a resident living on Dinting Vale, number 23. I've been there for 37 years. I'm also chair of a group called High Peak Access, who've looked at this application from an access point of view for disability in particular.
Thank you, Mr. Bennett.
Mr. Philip Miskell.
Can you just spell your surname out just for certainty for me, please?
Mike, India, Sierra, Kilo, Echo, Lima, Lima.
Sorry, just slow down one moment.
What's the accent, sorry?
I was just right. I was just
From
right.
Manchester, really.
Yeah.
It's Mike, India,
Yep.
Sierra,
Yep.
Kilo,
Yep.
Echo,
Yep.
Lima,
Yep.
Lima.
Thank you, Mr. Miskell.
And I reside Adderley Place, Symondley, and I'm speaking on behalf of 850 petitioners who object.
Thank you. Anyone else who wishes to speak?
There are other people, the traffic's really heavy coming down from Symondley at the moment.
Okay.
So they're struggling, there will be here presently.
Yes. We do have a draft inquiry programme, so after the openings we will be taking a break. So that should give the opportunity for people who wish to speak. I will take those who have registered in order now, but if there are others who wish to speak in that session, I will ask and we'll take them at that particular point as well. Thank you. Is anyone from the press present? I'll take silence as a no. So, finally, just before moving on to other matters, I just have to confirm that I do have a colleague in the room today observing the inquiry. In the interest of certainty, whilst you may see us in conversations during breaks, in today's proceeding, my colleague has no role or involvement in the inquiry. Okay, in terms of filming and recording, obviously we are live streaming, but does anyone intend to film or record the event? No. Okay, and no one has any particular objections to being on the live stream or being filmed during the proceedings, so those who can't be present today can still view it from elsewhere. I'll take silence as a no. My assumption is it's purely live stream and there isn't any recording. There's a backup recording. Can I just ask how long that recording will be kept? And it will be the responsibility of the council for data protection purposes.
Yeah. It's the council's normal procedure to keep it available for 6 months.
Okay.
I see no reason why it won't follow that process in this case. I'm sorry. Yeah, 6 months is the normal time zone.
Thank you. Like I said, I'd just remind the council that the data protection responsibilities will be with the council holding that data. So that's just a reminder for the council. Now, if there's no specific questions on filming and recording, I'll move on to notification letters. Now, I have a copy of the council's letters of notification of the appeal dated the 18th of March 2024 and a list of those notified, and a copy of the letter informing interested parties of the date, time and venue for the inquiry dated the 21st of May 2024 and a list of those notified. There's also evidence of site notices having been posted on the 1st of June 2024 informing interested parties of the date, time and venue for the inquiry, together with a map of agreed locations where the appellant has posted the site notices, I believe. Are there any comments or points of clarification with respect to the process and notification before I move on? Okay, moving on to representations. Just to confirm, I do have copies of representations made in response to the planning application consultation and the appeal notification. I will take those into account in making my decision. Now, in terms of a case management conference call, some of you may have seen a case management conference call took place on Friday the 10th of May 2024 with representatives of the appellant and the council. It was held to discuss the procedure for the inquiry, and the merits of the appeal were not discussed. A copy of the case management call summary note is available on the inquiry website. Following the case management conference call, there has been separate correspondence between the 24th of May 2024 and the 31st of May 2024, exchanged between the council, the appellant and myself regarding matters that had emerged relating to a footpath and cycle link between the site and, I may get this wrong, this pronunciation, and people may want to correct me, but is it Gamesley or Gamersley? Gamesley sidings. So a copy of that, all that correspondence is also available on the inquiry website. Are there any queries regarding the case management conference and its purpose? Are happy for me to move on? Okay. So the plans. There are quite a significant numbers of plans and quite a number of amendments that took place during the application. For certainty, for both I and anyone who's participating or observing, Are the plans before me and those which are to be considered, those which the parties have referred to, and when I say refer to the parties, it's the appellant and the council, in the suggested condition number 2? Are those the latest version of the plans for consideration? I
Yes.
believe they are the same,
Yes.
broadly the same ones that are listed in the core document list. I have some questions about referencing later in the inquiry
Yes.
that we'll probably discuss.
The
but
plans that you're invited to approve are those at draft condition 2 that you just referred to.
Thank you, Mr. Barry. Just for clarification, it's for me to consider at this particular point, but I understand from the appellate's perspective that's what you do wish. Okay, I'm assuming there's no additional plans to be submitted at this point. They should have been submitted already. Okay, moving on to the documents. All the documents and evidence should already have been provided, unless I've specifically requested it or it's been notified that it's due to be received already. In that respect, I would be grateful if the parties can just confirm when I'm likely to receive the request I made via email on the 14th of June for the agreed calculations relating to the housing requirements and high peak that should be considered for the purposes of the framework. For clarity for the parties, why I requested that is the most up-to-date evidence that was submitted to me, which was prior to the new National Planning Policy Framework update, which was in December. So the most recent publication on housing land supply that the council made was in November. There were changes in the framework that were material that would alter the position potentially. So that's why I requested that at this particular stage, because it may help the inquiry as we move forward.
So I think it's work in progress. I saw an exchange of email that was taking place yesterday evening, including quite late into the evening. Unless I'm going to be corrected, I think the latest iteration was the suggestion that we made, and I think that's still with the council. I don't know what their response is to the latest version.
The factual position is that since the December 2023 publication of the revised NPPF, the council has not produced its annual update to its housing land supply. That won't surprise you. No. The base dates are 1st of April or 31st of March, depending on which authority you're in. And those don't usually emerge and see the light of day until about July. Now, if you're asking what would the figure be if simply the buffers were removed from the 1st of April 2023 base date position, we can obviously do the math and tell you what that is. But and it will make a fractional difference. It always does. The agreed position in the statement of common ground is a 6.4-year housing land supply. It would go up slightly if we removed the buffers on the maths, but it will not change to any degree that would be material as to its weight. And therefore, if you want to know what the figure would be if we removed the 5% buffer built into that calculation, I'm sure we can tell you. If, on the other hand, you want to know, is it going to make any material difference to the planning balance? From the council's point of view, the answer is no, it won't.
Thank you, Mr. Richards. I think the question that I'm asking is both, effectively.
Right.
I understand the council's position with respect to the housing land supply and that the update is not due. The prior publication was in November for April the previous year. So I do understand that position, and that wasn't what I was asking for in terms of a full housing land supply update. What I was looking for was an up-to-date position for the purposes of the framework as to how it would be calculated relative to whatever housing land supply you think should be applied to it at that particular point as the most up-to-date.
Yes, well, I mean, neither of us is proposing to lay a figure before you with any different base date than the 1st of April 2023.
Which is understandable, yes.
Yeah. And without wanting to press the matter, is what you want to know simply, what would the figure be if you applied the December 2023 approach to buffer?
Well, yes, the December 2023 approach in the framework, yes.
Yeah. Well, we can probably
can
probably
agree that,
retrofit that.
Yeah.
But as I say, we'll present that to you. But as far as the council is concerned, it's not going to make any difference to the weight that one would give to the benefit of delivering housing.
That would be our position as well, sir. But we'll do the figure so that you have the accurate figure. But the position is that there is at present a 6.4 year supply. It will go up slightly, but the net result is that there is still a 5 year land supply demonstrated by the council.
Yeah.
Yes, it's just for certainty in
accuracy.
terms of my understanding and the position, so that if I refer to it in my decision in due course, that I'm not referring to an out of date approach.
Yeah, that's fine. We will produce you a very short note that will be, I'm sure, agreed between the two of us.
When can I expect that?
Well,
At the end of lunch today.
yeah.
It's not something that's immediately pressing, but it may be something that emerges particularly in relation to the planning witness.
Evidence and the balance. So yes, I understand that. But it's a simple mathematical exercise. We should be able to produce a figure, an agreed figure, certainly when you resume after lunch.
Yeah.
Thank you. And the other matter is in relation to the planning, in terms of documents, is in terms of the planning obligation. I understood from the correspondence there was a deadline. It was an extended deadline last week for draft planning obligation. I understand the parties were working through the aforementioned issue in terms of the access link, and it did go very much towards and potentially beyond the deadline, so I assumed that negotiations were ongoing, whether the parties can confirm those negotiations are ongoing and whether there's an intention for a further draft to be submitted to
Yes.
me.
So the negotiations are ongoing, and I don't want to draw a veil over any potential acrimony. So can you leave that with us, and we can update you at the close of business today as to where we think we are. I think you, sir, will end up with a unilateral undertaking.
For just that aspect, or in total, or will it be a unilateral undertaking generally? Because I think there was a suggestion that it was a kind of hybrid form, the draft that I had.
Yeah, just to let you know, the county council are also involved in the discussions. I hold no brief for the county council. How can I put this delicately? The lack of any final agreement is because the county council are not as yet persuaded of the merits of some of the arguments, as I understand the position.
Yes.
Mr. Barrett, anything to add on that point?
Yes, I think Malone Friend's putting it very delicately, but I don't disagree with it.
Right. That was all the updates that I needed on documents at
So
this
there was
particular
one
point.
request that you made of us for hard copies of CD 4.1A, B through to 4.6B. So
Okay.
I've got a copy of those. Would you like them now, or?
Yeah, I'd have the council seen them.
Yes, they're inquiry documents.
Yes.
Yeah,
we've
we've seen them electronically.
Yes. Yes. No, hard copies fine to be provided. Thank you.
Yeah, local plan. Yeah, they're local plan extracts.
Yes, it was the policy extracts that I'd requested previously. Yes, I was happy for it just to be added to the core document library, but I thank you for the hard copies as well. Thank you. I'll accept it as inquiry document 3.
So, can I just say something about documents, primarily for the benefit of the public? If they put into a search engine Dinting Vale public inquiry, then that will give them at the top of the list a link to the documents page for this inquiry, and all of the documents by core document reference number will be instantly available at the press of a finger. And that's how we're operating the availability of documents for this inquiry. So just search Dinting Vale public inquiry and all should be revealed. He says, noticing out of the corner of his eye that somebody's just put their hand up.
Yeah, in relation to information on the portal, a lot of the documents cannot be opened. It's been a constant complaint right throughout this process, right throughout when the application was first put in. Documents are not accessible to the general public. They will not open for some reason. It's on record that we've written to Ben Haywood and the council in the past as regards this problem. And I recently experienced it not 2 days ago, trying to access one of the documents the gentleman was just mentioning.
Thank you, Mr. Miskell. There are, as far as I'm aware, there are hard copies of the core documents in the corner.
There are.
In the corner over there. So if people do need them during the inquiry to refer to them,
yeah.
there is an opportunity to access them in hard copy in the corner of the room. I'll give the council an opportunity to respond in terms of loading times, etc., in terms of downloading documents from the core documents list.
The answer is I don't know personally. Personally, I haven't had that difficulty, but I will call some investigations.
If people let us know which documents are not opening, I haven't had any difficulties, but if people let us know which ones are not opening, we can investigate it.
Okay. Yes. If people in the room want to pass my instructing solicitor a note as to which documents they're having trouble opening, we can investigate that. But otherwise, it's slightly difficult to deal with it on the hoof.
Thank you. One thing I can say is that I have used the core documents list on the website, and I haven't had the problem of documents not opening, but I do recognise that sometimes the loading times can be quite significant on some of the documents. Particularly there are some particularly large ones on there. Like I said, for those participating, there are hard copies on the table over there, in the corner over there. So if there are any documents that you need to refer to in hard copy, then the opportunity is there, whether during breaks and so on. You can obtain those copies and refer to them. That's the library for the inquiry. But I will trust the council to investigate and see if there's anything that can be done about the electronic copies of the documents and accessing them and downloading them, how that can be done effectively. Thank you for bringing that to my attention, Mr. Miskell. Okay. So I've got so far I've got three inquiry documents. I've got the appearances sheet from the appellant, the opening from the appellant, and the planning policy extracts that have also been added to the core documents list. The reason why I requested those, they were policies that were referred to within a range of other correspondence that may be raised during the inquiry. So for completeness, to have those extracts in the core document library was necessary. Are there any? I'm not inviting any more late evidence, but is there anything that anyone wishes to provide at this particular point before I move on? Okay, only exceptionally will material received after the close of the inquiry be taken into account, unless I specifically request it during the inquiry. Typically, this would be a signed version of the planning obligation following discussions. Understandably, the planning obligation will remain open and unsigned because of discussions that are needed to be had prior to its finalisation, and those discussions will be without prejudice to the outcome of the appeal. It's just normal process. Okay, if there's no further questions on documents, we'll move on to planning obligation and conditions. So I have a final draft planning obligation, and the detail of what is proposed to be secured will be a matter for discussion later in the inquiry. I set out in the case management conference note that typically at least a week, normally the Friday of the following week, after the inquiry is closed, would be allowed for that signed copy that I just referred to. Just to ask the parties at this particular point, do you believe that to be feasible, or is it dependent on the discussions that are likely to be ongoing and take place? And if there is an alternative, is there an alternative that you'd like to suggest?
So I'm optimistic, and I think it is feasible that you will have a completed Section 106 either at the end of the inquiry or very shortly thereafter.
Thank you. I also have a suggested list of conditions, and similarly, those will be discussed in a session that's currently programmed in week 2. And again, that's just normal practice. It doesn't mean that I've made up my mind. It's just a matter that needs to be discussed in the event that planning permission is granted. If possible, during this week, I do hope to provide some initial comments on the draft planning obligations and the draft suggested conditions that will form the basis for the respective discussions programmed next week. Do find that to be helpful to scope down
that would
the
be
issues.
very helpful, sir, I'm sure.
Yes, I'll provide it as soon as possible, and if possible, but just to let everyone know that is my intention. Okay. Are there any specific comments at this stage or queries before I move on about the planning obligations and conditions?
Not from my side, thank you, sir.
No, sir.
Okay. So, moving on to procedure and proofs of evidence. During the case management conference, the approach to dealing with the evidence was discussed to explore how best to hear the evidence to ensure that the inquiry is conducted as efficiently as possible. The Council made its decision on the 23rd of October 2023 with 4 reasons for refusal, which identified perceived associated conflicts with local and national policies and broadly related to, firstly, the potential for increases to the level of air pollution in the air quality management area designated on the A57 Dinting Vale. Secondly, the position of the proposed highway access road from the A57, including its proximity to a nearby primary school and the potential to result in unacceptable risk to road safety. Thirdly, that notwithstanding the viability issues noted, the proposed planning obligations referred to as a Section 106 package would fail to achieve policy compliant levels of affordable housing, fail to fully mitigate substantial tree loss and loss of biodiversity on the site. And finally, the fourth was the potential for the public right-of-way onto Simonley Lane to be used for vehicle access, that it would pose a risk to safety of the users of a public right-of-way and a highway, with a safety risk at the junction with Simonley Lane. Following those initial positions of dispute between the main parties, the Council indicated on the 22nd of April 2024 that they do not intend to offer evidence in relation to and sought to withdraw the 3 reasons for refusal that related specifically to, insofar as they related to air quality and highway and pedestrian safety. A further email dated Tuesday the 7th of May 2024 confirmed that the aspect of the reason for refusal relating to biodiversity is no longer in dispute between the main parties, as the Council is satisfied that the appellant is proposing full mitigation. Following the case management conference and prior to the inquiry opening, the Council confirmed through emails on Tuesday the 11th of June 2024 and the submission of a statement of common ground on Wednesday the 12th of June 2024 that they are no longer to offer evidence in relation to the remaining reason for refusal, and that was number 3 on the decision letter insofar as it relates to affordable housing and the effect on trees. In doing so, the Council confirmed that having considered the appellant's proofs of evidence and having taken advice from the Council's viability consultants received on the 6th of June 2024, the Council had concluded that the appeal could not be resisted. I just want to check with the Council. My understanding of all that position is correct?
That is correct, sir, and I shall confirm it in writing in opening shortly.
Thank you. For certainty, notwithstanding the resultant situation that there are no specific areas of dispute between the council and the appellant, there won't be any cross-examination of witnesses as a result. However, the inquiry necessarily does continue, and I have evolved the inquiry timetable to ensure that I can obtain the necessary information that I need to make my decision in due course. This includes opportunities where I will invite interested parties to offer their views should they wish to do so on matters relating to highways, civil engineering and access today, and a further opportunity to offer evidence on all other matters included within the programme during tomorrow morning. There are also necessary time slots included in the programme to allow the appellant to call 5 witnesses to present their evidence addressing highways, civil engineering and access, air quality, arboriculture and ecology this week, and a further 2 witnesses to present their evidence addressing viability and planning matters next week. I will be asking my own questions of each of the witnesses to assist my understanding, but Mr Barrett, can you confirm whether you'd be happy for those participating in the inquiry to also ask their questions?
So yes, any member of the public who takes the position of objecting to the proposal, as far as we're concerned, is entitled to ask questions and hear the answers given by my witnesses.
Thank you, Mr Barrett. My intention is, you may note during in the inquiry programme that I did give a little bit of flexibility in relation to the timings that were suggested. That was deliberate to allow the opportunity for questions before my own.
That's what I anticipated, sir. I think
yes,
that's
it's just for certainty, so that I wasn't ignoring the timings that you gave me. It was to build that bit of flexibility.
Thank you.
Okay, in terms of that draft programme, just to confirm, and as Mr Richards referred,
Sorry, Chair.
Councillor Hardy?
I won't be available tomorrow. My problem is the air quality aspect of this application. Would I be able to speak today? If that's all right, I definitely won't be able to be here tomorrow at a funeral. And obviously we didn't get any programme of what was being discussed on a daily basis, on an hourly basis.
Yeah.
Would I be able to speak today?
Yes. Just to confirm, the programme was circulated on Friday. It is a draft programme. Obviously, there are circumstances that cause difficulties sometimes for witnesses, and I will allow some time today, given the constraints that you've given Mr Hardy. What I will do though is I'll call the highway witnesses first, and then allow you to speak on air quality. So there's a distinction between because and obviously to group the highways together to ensure that points seek to avoid repetition, because it's the point raised rather than how many times it's raised before me. Okay. I saw another hand. Sorry.
Yeah, sorry, I can't attend tomorrow either, so yeah, I turned up today.
Right, you may have arrived slightly before the start when I took registration from people who wish to speak, but I'll take your registration now, and I will. It's similar to Councillor Hardy. I will invite you in the time that we have today. Can I take your name and who you're representing, please, or you just?
And I am a resident of Adderley Place.
And I assume it's an objection?
Yes.
Thank you. Thank you. Are there anyone else who arrived who wishes to register to speak, who may not have?
Can you just clarify which points you want to hear about today? So is it just about access and highways?
The programme today is for access and highways, but if you're unable to attend the session tomorrow, that's all remaining matters. I'm happy to take those points as well.
So in terms of access, are you talking access from Dinting Road, the A57, because we particularly want to talk about access for Adderley Place residents?
It's highways and access matters, so it's what you consider relevant to the proposal in that regard. There isn't a specific specific restriction in terms of matters to be raised, because I'm assuming you've already raised them similarly in reps received so far. Okay.
There
Mr.
are
Whittle?
persons who wish to come down and pass comment on this appeal, but unfortunately you can't make it today. Will there be opportunities for them to speak over the course of the coming days at some stage?
Well, like I said, there's a second opportunity tomorrow for statements to be made. So the primary 2 days with today and tomorrow. If there are constraints that are drawn to my attention, I can look at the programme to see if a further opportunity needs to be given if people have constraints on attendance during those 2 days. But they will need to let the council know to inform me or the case officer, as that may be. Thank you. Okay. So in terms of the draft programme, it is available on the inquiry website. It is subject to change, and if there are any significant or material changes that are made to the timings or movement of sessions as a result of progress that we make during the inquiry, a revised timetable will be published on there. So I would recommend that people do keep an eye on the inquiry website that Mr. Richards referred to in terms of accessing that detail. There are some paper copies on the end of my desk that I will put by the registration area, so people can get hard copies. They are very limited though in terms of the number that I've got. So, but if interested parties want to share them between themselves so they can understand the sessions, if they can't get access to the inquiry website right now, that might be helpful to refer to those documents. I will, at the next break, I'll place them on the table where the attendance sheet is. And just to remind those who may have arrived a little bit late, we do need you to put your name down on an attendance sheet at the front. That's for fire purposes. The evacuation procedures are through this door if we hear a fire alarm, because there's no test plan today. And there's also separate documents for you to put your car parking details on if you parked here. Okay, thank you. Have parties any other queries with regard to the inquiry programme and that's scheduled?
No, sir. It's caveated as we would expect, with the asterisks that say these are matters which might be brought forward or pushed back depending on progress or lack of it that we make. No doubt we'll just keep it under review in the normal way.
Yes, I obviously I did put the asterisk there to allow us some flexibility for things to move in the circumstances, dependent on how long things are, and there are some contingency timing to account for situations such as additional statements for residents, etc., which I'm assuming the parties don't have any issue with taking those statements now rather than in the allocated time slot. It isn't my intention necessarily to bring forward witnesses, for example, bring forward tomorrow's witness to today,
yes.
Because I know the difficulties that can cause for witnesses and in terms of preparation and so on. But it may be the case as we get further through the inquiry, if we do make swifter progress, then imagine that I would discuss it with the parties if there was the possibility whether it would be feasible for certain witnesses to be brought forward. Albeit I understand one of the witnesses can only attend next week.
Yeah. Well, thank you, sir. You're absolutely right. One of my witnesses can only attend next week, but I think we all acknowledge that with a degree of flexibility we should be able to arrange a timetable that meets everybody's requirements and the interests of fairness.
Yes, I agree, sir.
Thank you. Like I say, I'll any significant changes I will discuss with the parties and participants in the inquiry. In advance of the forthcoming inquiry sessions, I can confirm that I have read all representations made at application and appeal stage, together with proofs of evidence and the agreed statements of common ground. So I would expect them to be largely taken as read, other than queries and points of clarification I need to enable me to make my decision. As such, my own questions will be focused on the areas where I currently do not have sufficient information or understanding to make my decision. So there may be a point where you think there's an obvious question that I haven't asked. It may be the case that I think I've got enough information on that particular point. I don't need to necessarily hear anything from my perspective that I've already heard and understood. But that doesn't stop parties from asking their own questions if those questions are obvious to witness, and they consider it may assist me. Okay. Have the parties got a copy of all the proofs and associated documents or access to them? And the proofs, there's copies of the proofs available to interested parties as well within the examination library?
They are in the examination library. Sorry? Yeah, and there are hard copies, I understand, at the back, but I don't think that there would be sufficient for everybody. But there are certainly copies for people to refer to.
Yes, and that's fine. And my presumption is during evidence in chief, you'll be taking us through the key evidence anyway. Yeah. For interested parties and those observing who may wish to follow the discussions and cross-refer to the evidence, as said, all core documents are available on the council's website, and the hard copies are on that table as well. But it may just be a case of reviewing them during the break and taking what you need at that particular point, and make sure that you do return them so that others have got the opportunity to review the documents. Thank you. So moving on then to procedural matters and the conduct of the inquiry. Just to confirm, I will follow the procedure in the 2000 inquiry procedure rules. Inquiries are formal events, and therefore I expect all participants and attendees to be treated with courtesy and respect. To ensure the smooth running of the inquiry, all participants presenting evidence will be afforded the opportunity to be heard and make their case, and as such I'll also need to be able to focus on the arguments being made, so I will be grateful if people don't interrupt when evidence is being given. Thank you. Any significant disruption or interruption from others won't be accepted. This does extend to avoiding behaviour such as clapping, even if you agree with arguments raised. Just be mindful that we are in its formal proceedings. So I'll understand if you agree with the point. We don't need to hear it necessarily in that way. There may be occasions when I myself do intervene in the presentation of evidence. That is purely in the interest of the smooth running of the inquiry, to avoid repetition of points or answers already heard, or to prevent unhelpful or irrelevant questions. Please do not take this personally, and just understand that it is necessary to ensure that the inquiry progresses in a timely manner and is assisting me in getting the evidence that I need to make my decision. I'm also mindful that we are in the pre-election period, so I politely remind all parties that the presentation of evidence and associated questions should avoid comments and statements of a political nature or what could be perceived to be electioneering. In terms of the running order, the inquiry is scheduled to last for up to 5 sitting days, so it's 6 days in total. That's set out in the draft timetable. The extra day that we're not sitting is Friday, which is programmed for site visits, which we'll discuss a little bit later. Have everyone seen the draft timetable, particularly the main parties? Any specific comments or constraints in terms of the site visit? The site visit itself, there's 2 windows effectively. There were requests from interested parties in representations to view local highway conditions in the morning and afternoon, and I'm going to do the afternoon unaccompanied on Thursday, so I can assess the highway conditions. And also it was requested in the morning at school opening time, which again I'll do unaccompanied during the inquiry, but a formal site visit will be required on Friday as well. That's both to the site and to the biodiversity offsetting area in Chinley, I believe it's called. So and that will need to be accompanied by a representative of the council and the appellant. We also have a request to view. I don't know whether the representative is here today to confirm whether that needs to go ahead as well. But we did have a request, and we asked that it was drawn to our attention during the inquiry if that request to view was.
I'm just wondering, can residents be there at the site visit to walk the route and explain about the roundabouts and the other dangerous issues?
The intention of the site visit isn't to have a discussion. The formal proceedings are in the inquiry. There are opportunities potentially to observe the site visit and come along, but it won't be an opportunity for discussion and formal presentation of evidence, because it's a matter of fairness, because there may only be a select audience who may not be able to attend the site visit, and they won't be able to hear that particular evidence or be able to respond to it. But within reason, yes, there are representatives to observe, assuming that the parties are happy that the conditions of the site would allow it.
So there's no objection from members of the public, a limited number or selection of representative members of the public attending the site visit. Just be aware it can be quite wet at times, so suitable footwear might be a sensible precaution.
Thank you, Mr.
Yes,
Barrett.
and we'll
Mr.
be
Richard.
sending Mr. O'Brien as our representative to the accompanied phase, and we have no objection to your suggestion for the two unaccompanied phases.
Thank you. Well, the provisional details of the site visit are in the programme. On Friday, in terms of the accompanied visit, it would be meeting at 10 a.m. At the site. I will take advice on where the best meeting point is at that particular point at 10 a.m. And then my intention is that once that's complete, then to travel to Chinley, and again that to be accompanied by a representative of the council and the appellant. I note the appellant did refer to the Chinley site requiring access through the construction site, so there may be a need for PPE. So not just robust footwear. It may need high visibility and yes, safety wear.
We'll advise and, if necessary, even provide the high vis jackets for that part of the site visit.
Hard hats as well.
Yeah. Yeah.
Thank you. Now, on conclusion of my opening remarks, I will invite the appellant and then the council to make their opening submissions. This will help everyone to understand the main arguments and set the scene. I will then hear from interested parties who wish to speak today. We've already gone through it's primarily highways, but there will be an opportunity for those who can't attend tomorrow to cover broader issues. We will take those, start taking those comments from after the break. Following this, I'll hear from the appellant later today on highways, because I believe your witness has got a constraint in terms of attendance on
That's
any
right,
other
so
day.
my highway witness, yes.
Yes, so we'll take the highway witness before the end of today,
Yeah.
and then my intention was to group it together and then go to the access and civil engineer witness, assuming that we wouldn't get there today, that it will be tomorrow morning before we take the further statements from interested parties at that particular point. We'll then move on to hearing the appellant's evidence on air quality, arboriculture and ecology during the remaining sitting days of the week. Okay. In week 2, I'll hear the appellant's evidence on viability and planning matters. Again, similar format as described. We'll then go on to discuss the planning conditions, the planning obligations as per the inquiry programme. Discussion of those is normal practice, as we've said, and does not mean that I've made up my mind regarding my decision on the outcome of the appeal, and nor does it weaken the position of any party to participate in it. Rather, in the event that the appeal were to succeed and conditions were to impose, it does need to be of the benefit of discussion. Following that, I'll hear closing submissions from the council and then the appellant. Just a reminder that written copies will need to be provided, and no longer than, I think we said 30 minutes. Is that acceptable?
Yes, sir.
Thank you.
Yes, sir.
Yes, I assumed from the council. Yes. I'll then hear any costs application. Now, the appellant has already made an application for a full award of costs in writing on Friday the 14th of June 2024. The council have been given an opportunity to provide their response in writing by 5 p.m. on Friday the 21st of June 2024, and I presume that's in train.
That is in train, sir, and I hope that we will get it both to you and the appellant before that deadline. But that's the deadline we're working to. Well, personally, I'm working to close the play Wednesday, if that's any help.
Thank you. Well, I will ask for an update at the start of days, so that can be something that you can draw to my attention if you wish to submit it at that particular point. But I ask that you do share it in writing also with the appellant.
Yes.
Okay.
Yeah. The appellant will probably get it before you.
Well, yes. During the inquiry, can I just ask? Can I just ask that alarm to be turned off or muted, please? Sorry. Okay. During the inquiry, the parties will be given the opportunity to update the written costs application and the written response orally, should it be necessary, and then the costs applicant will be given a final chance to respond. I am also required to remind you that I do have the power to initiate an award of costs, whether or not a costs application has been made by parties. Were I to do this, it would follow a written process with the relevant party after the appeal decision is issued. Any comments on that particular running order?
No, sir.
No. Okay. Please note the running order is draft. We may overrun, we may bring things forward as noted on the draft programme, but we'll try and keep it as fair as possible for those to attend and participate. Okay. In terms of breaks, I plan to take a break for lunch around 1 o'clock each day. It may come forward on occasion if it's a natural break in proceedings. There will be short breaks in the morning and afternoon, so there should be up to 4 sessions today. I'll aim to finish around 5 and not sit later, ideally. On subsequent days, I do intend to start at 10 a.m. That's slightly later than originally discussed at the case management conference, but I think, having looked at it, I think presentation time for witnesses, that extra half hour may be useful in the circumstances. Okay, and also for those who may want to travel here to access it conveniently and not quite as pressed during rush hour. I will keep the timings under review as we progress, and if anyone thinks an adjournment is necessary, particularly advocates and spokesperson, please let me know at that particular point in time. Just before we move on, just to let people note the position of the witness table. That's where I'll hear from witnesses at various times, and I'll also ask interested parties to go to that desk when presenting their evidence. I'm assuming everyone's okay with that. Okay. Right, now moving on to the main issues and other matters. Having reviewed all the evidence to date, whilst there are now no main issues in dispute between the appellant and the council or identified harm that they consider could not otherwise be overcome by the imposition of conditions or planning obligations, interested parties have expressed concerns on a number of matters. As such, I anticipate that I will address the following issues specifically in my decision. So, again, similarly, the effect of the proposed development on air quality with particular regard to the air quality management area, the effect of the proposed development on highway and pedestrian safety, including the means of access onto the A57 and the relationship with the public right-of-way and the access onto Simonley Lane, whether the proposed development satisfies policy requirements for the provision of or contributions towards affordable housing, having regard to financial viability, the effect on trees and the effect on biodiversity. The manner within which any additional matters raised dealt with in the eventual decision will depend upon the evidence as it emerges during the inquiry. So that's not a closed list. If matters are raised and they do require to be elevated to the status of main issues, you'll see in the structure of the decision as it's issued, they will be if the evidence is presented and I consider it necessary. Has anyone got any comments at this stage on the identification of those issues? Anything that need me to consider at this particular
No, I
point?
think that covers everything, sir.
Thank you. Well, unless there's any further questions at this particular point, that concludes my opening remarks. And anything on procedure or other matters before we start?
So there's just one matter, and I don't want this to be too controversial. It has been, the interested parties will be giving their evidence before Mr. Roberts, and your site visit, sir, is scheduled for Thursday afternoon and Friday, and that's been known for some time. It's been drawn to our attention that there was a communications, I think by Facebook, that has actually invited people to park their vehicles at Dinting Vale on Thursday afternoon and Friday morning. We've got an extract from that Facebook page, and I'd like that to be distributed. So it shouldn't affect your site visit one iota, but it is perhaps a matter that you should take into account when conducting that site visit. Have you got a copy of it?
Thank you, Mr. Barrett. Has that been shared with? Has that communication been shared with the council so far?
Not so far. I only got this morning, just before the start of the inquiry.
Okay, so can I ask the parties at the break after the openings to review that review that evidence together, and then come back to me with what your views and whether you've got a suggestion in the approach that I should take to it.
So yes, we can have that discussion.
Yes, prior to any acceptance of an inquiry document, just
happy
to discussion, please.
Very happy to do that, sir.
Just to confirm at this stage, it does strike me that obviously it's within my gift to undertake unaccompanied site visits at different times, which won't necessarily need to be announced within the programme, and that may be a solution if there are concerns of the parties that it may not be representative. But I will leave that with the parties in the break. It is my intention still to do the site visit at that point in time, but it will be within my gift to undertake verification at other times should I feel the need to do so.
Thank you for that confirmation and clarification. Yeah. Got it.
Okay, unless there's any particular comments and queries on that particular point, and which we'll return to after the break. In that case, Mr. Whittle.
Is it possible to be provided with a copy of that Facebook copy?
Yes. Do you want it now?
Please, yeah.
At the moment, it's not an inquiry document. It's not in the public domain. But
It's not an inquiry document, but it's annoying.
Mr. Whittle, if you can direct your comments through me, please, and then I'll direct it. Just in the interest of the inquiry proceedings.
It's not an inquiry document, but it's annoying. The thing is, it's on a social site, a social network, which you do get adverse comments or comments like this, which are not welcome. But in addition to that, I'll be highly surprised if a lot of them can make the time to get there, and people can't make you have to get in and out of it. I'll be highly surprised if you can find a place for parking at the times they've mentioned.
Thank you, Mr. Whittle. Just through me rather than through.
First inquiry.
No, it's okay. I do appreciate it, but just for everyone really, it's through me, and then I'll direct the points to the parties.
This is the problem with social network sites. You invite all sorts of comments, and some people throw ad hoc comments out there just to put the cat amongst the pigeons. And I can assure you this has not come from a... Sorry?
Yeah, sorry. No, sorry, your
Yeah.
name? Yeah.
Councillor Hopkinson. I know this person who's put the comment on. I'm not happy with it. I've had run-ins with her. She's very, very argumentative. It's not helpful.
Can I just sorry? Can I just ask one?
She doesn't live nearby.
Can I just ask one at a time? One at a time, please. Right. Okay.
She doesn't live in the area at all. She lives in Old Glossop.
Okay. Well, we'll return to the point after the break. But and obviously I've left my potential solution as my gift in terms of conducting an unaccompanied visit at a separate time, unannounced. If I have any concerns that what I experience aren't representative. So my assumption is that there wouldn't be any objections from the parties that were at to do that. That any times that I did undertake the unaccompanied visit would be noted on the decision letter, so it would be clear when I'd actually done the times that I'd actually done them. So the site visits are included on that particular point. That would be what I've obviously proposed in the inquiry, if I do consider it to be an issue. But I do want the parties to review it between themselves, that correspondence, to see what the potential risk is in terms of whether that site visit isn't going to be representative of what I should be experiencing. Okay, thank you. Mr. Whittle.
Just state that it actually does the group we wrote to them. I know you did your service. This is not what we're about. We're actually opening up from no shenanigans, I'll put it that way. I can only apologise for a person who's not a member of our group.
Thank you. I appreciate that, and I understand that it's not an ideal situation for people who are attending the inquiry to be put in if they've not been part of it. But there are ways and means that I can obtain the information that I need. So it's just a matter of procedure, given that it's been brought to our attention, just to confirm what the alternatives may be. Thank you. Okay. Assuming there's nothing further on that point, and my opening remarks have concluded, then we'll move on. May I ask the appellant's advocate to start with the short opening statement? I'm presuming it's the same as in inquiry document 2.
Yeah, I hope so as well.
Yes.
They've been distributed, so that there are a number of copies in the room. Let me begin with an opening, as brief introduction. As probably everybody knows, the appellant is seeking full planning permission for a development of the following description: a proposed residential development comprising 92 dwellings, including areas of public open space, landscaping and associated works. Dealing then with the appeal site and its surroundings, the appeal site lies approximately 1 kilometre to the west of Glossop town centre. It's located to the south of Dinting Vale, the A57. It is approximately 4.7 hectares and, as will be discussed later, is part of a larger 6.3 hectare greenfield site allocated for residential development for approximately 130 dwellings. The northern section of the appeal site is overgrown with trees and shrubs, and the topography of this part of the appeal site slopes, with levels falling northwards towards the A57. The southern portion of the appeal site is generally open grassland, where the levels slope from west to east. Trees on this part of the appeal site are generally located around the periphery, and this area was last used for horse grazing. To the north and west of the appeal site are existing residential dwellings. The Dinting Church of England Primary School and Holy Trinity Church are located on the north side of Dinting Vale, northeast of the proposed access point that will serve the development. Then turning to the planning application and its determination, the appellant signed a planning performance agreement with the local planning authority on the 2nd of November of 2022, following pre-application discussions on the scheme. The planning application was validated the following day and given a planning reference number, which I won't read out. The planning application was supported by a number of detailed reports. These included a planning statement, an air quality report and technical note, an LVIA, that's a landscape visual impact assessment, an ecological assessment, a tree survey, a transport assessment, and a viability assessment and addendum. During the course of the consideration of the application, constructive engagement was undertaken between the appellant and its consultancy team, the local planning authority's professional officers, their independent consultants, and the statutory consultees. This resulted in a number of amendments to the proposal, including a reduction in the number of dwellings initially proposed from 100 to 92, as in the current description of development. The planning application was reported to the Council's Development Control Committee on the 23rd of October 2022, with a recommendation that planning permission be granted. Members voted to refuse the application, contrary to that recommendation, and the decision notice was then issued on the 27th November 2023. In summary, the reasons for refusal stated as follows. The first reason, refusal, related for the potential for air pollution in the area to be increased. Secondly, an unacceptable impact on road safety because of the position of the proposed highway access from the A57. Thirdly, a failure to achieve a policy-compliant level of affordable housing and failure to mitigate the substantial tree loss and loss of biodiversity on the site. And finally, the fourth reason was risk to the safety of users of the existing right-of-way and the prospect of a rat run. An appeal against the refusal was submitted, and then a further meeting was held on the 22nd April 2024 by the Council's Development Control Committee, some 5 months after issuing the decision notice. At that meeting, the committee resolved not to pursue a defence in relation to reason for refusals 1, 2 and 4, and provide no evidence in relation to those reasons for refusal at this inquiry. The position has been confirmed by the local planning authority in its statement of case, stating that the 3 reasons for refusal, quote, are not contested and are duly withdrawn by the council, end quote. That position of the local planning authority was further confirmed at the case management conference on the 10th of May. Reason for refusal 3 contained in part an element relating to the biodiversity impact of the proposal. By an email dated the 7th May 2024, it is agreed that reason for refusal 3 relating to biodiversity is no longer in dispute, as the Council is satisfied that the appellant is proposing full mitigation. The Council's position on this issue was also again confirmed at the case management conference. As a consequence, the remaining element of reason for refusal 3 was the failure to achieve a policy-compliant level of affordable housing and mitigation for tree loss. The Council's statement of case stated that it did not dispute the details of the viability assessment submitted with the application, but it then added, and I quote from the statement of case, it is considered that there were full site the full site allocation taken out. That's for the purpose of my opening. That's the full 6.3 hectare site. Then there is no evidence as to whether viability would have been improved so as to provide enough financial headroom to mitigate identified biodiversity harms and affordable housing. End quote. The appellant did not and does not consider it's required or necessary to address viability on an allocation-wide basis, but in its evidence for this inquiry, it addressed that issue. The most up-to-date position is derived from an email dated the 11th June 2024 from the local planning authority to the planning inspectorate. The council has confirmed that having considered the appellant's proofs of evidence, and that included a viability assessment of the whole allocation, and taking advice from viability consultants, the council has concluded that the appeal, quote, cannot be resisted, end quote. I then turn to the main issues. Whilst the local planning authority has withdrawn its case against the proposal, the appellant recognises that many local residents and objectors to the scheme had adopted the substance of the reasons for refusal as their own case against the development proposal. As a consequence, to address the issues at this appeal, the appellant proposes to call 7 witnesses dealing with the following topics: highways and highway safety, civil engineering access, that's the access A57, air quality, arboriculture, ecology, viability, and the planning policy imbalance. And then turn to the development plan. National policy in the National Planning Policy Framework sets out that the planning system should be genuinely plan-led and include a framework for meeting housing needs and addressing other economic, social and environmental priorities. The appeal site was allocated in the adopted local plan for residential development, along with a further area of land that's owned by the council. The council, in the course of the preparation of the local plan, had promoted the development of the site, and it was expressly considered by Inspector Michael Moore in the course of his report of the examination in public of the proposals contained within the local plan. He found that with the addition of a requirement for a wildlife survey as part of policy DS4, quote, "the site is sound," end quote, said Inspector Michael Moore. The local plan was adopted then in April 2016, and the total of 6.3 hectare allocation was the subject matter of policy DS4. The allocation is an acknowledgement that the principle of residential development is acceptable. The statutory provisions contained at section 38 subsection 6 of the 2004 Act applies, such that a decision maker is required to determine the application in accordance with the provisions of the statutory development plan unless material considerations indicate otherwise. The council reviewed the local plan in June 2022 and concluded that some elements of the plan were out of date. Importantly, however, policy DS4 that relates to the allocation of the appeal site was not deemed to be out of date. The requirements of policy H4, and that relates to affordable housing and viability testing, also remain relevant for the appeal proposals. The status of the appeal site as an allocation for residential development, in light of the plan-led system, is of fundamental importance in the determination of any appeal. In determining that the application ought to be refused, members of the Development Control Committee appear to the appellant to have been resiling from the fact that the allocation was itself recognition that the principle of residential development had already been established. Nevertheless, the appellant proposes to address a number of concerns as expressed in the original reasons for refusal that have been adopted by objectors and local residents and others in relation to the scheme. Highway safety and access, briefly as follows. Access to the appeal site is proposed from the A57 in accordance with the site's allocation under policy DS4. This recognised that the provision of the access would involve a significant engineering operation having regard to existing levels. The issue to address is whether there would be an unacceptable impact on highway safety. In this regard, the principal objection relates to the proximity of the access to the school, which, according to many objectors, creates an unacceptable risk to highway safety. The appellant's transport assessment and technical note address the concerns relating to the proximity of the access, noting that the same could be accessed safely and satisfactorily from the A57. The Highway Authority, in fact, who would have considered those documents, do not raise any objection to the location of the proposed access. Air quality. The concern in relation to air quality is that as a result of increased levels of traffic in the vicinity of the air quality management area, there is potential to increase air pollution and concerns about the impact on the health of people in the area and in particular children. In this context, policy EQ10 and policies at paragraph 109 and 192 of the National Planning Policy Framework are relevant. The planning application was accompanied by a transport assessment, an air quality assessment, a travel plan, an energy and sustainability statement, and proposals for electrical vehicle charging and cycle storage. The council's own environmental health officer did not object to the proposals and did not dispute that the effect of the development on air quality was, quote, negligible. The appellant has put forward a package of measures in order to address air quality issues. The evidence will demonstrate that the development would not harm human health and there would be no conflict with policies of the local plan or the framework. Biodiversity. The appellant, through the planning obligation, intends to secure the full suite of biodiversity mitigation measures that are required. As a consequence, there will be no conflict with policy DS4 and any harm will be appropriately and fully mitigated. The appellant has continued its discussions with the Derbyshire Wildlife Trust to secure the biodiversity net gain strategy and a 30-year management plan, BNG, that's biodiversity net gain assessment, and the costings of the bespoke compensation package at Chinley, again, plus 30 years of management. Notwithstanding the fact that the application is not the subject matter of the Environment Act 2021, the scheme would actually deliver 11% BNG. In this regard, the BNG calculation in fact takes no account for the replacement trees being planted by the council by the off-site contribution of over £72,000 plus a further £20,000 for maintenance. Arboriculture. The allocation of the site under policy DS4 with a requirement for an access from the A57 inevitably necessitated the removal of a significant number of trees. The appellant's evidence references policy EQ9 of the local plan and the framework in relation to those trees. It's apparent that part of the rationale for the council's 2-to-1 replacement was because many newly planted trees do not survive. That is contrary to the expectation of the appellant's evidence that expects a success rate in excess of 90% and that any failures would be replaced in accordance with any conditions imposed upon any grant of planning permission. A robust and reasonable replacement planting scheme has been proposed and is readily capable of being achieved. Affordable housing viability. The local plan anticipates a contribution of 30% of the housing would be affordable. The vehicle for securing affordable housing is policy 4 of the local plan. The policy, consistent with the framework and planning guidance, is qualified to the extent that where it is demonstrated by an applicant or appellant that there are viability issues, a reduced provision is permissible. The planning application was accompanied by a viability assessment and revised to reflect the reduction in housing number. That's the viability addendum. That was independently assessed on behalf of the council by consultants Bruton Knowles. They concluded that some £793,000 was available for planning obligation contributions. That was not agreed by the appellant's own viability consultants, but in the hope of moving the application forward and achieving approval at the local level, that sum was accepted by the appellant. The appellant is not proposing to make any contributions towards affordable housing. It will be recalled that the council, in its statement of case, had raised the issue of making a viability appraisal for the whole of the allocation within the local plan, covering some 6.3 hectares. That was undertaken in the evidence that has been submitted to this appeal. That additional assessment demonstrates that in accordance with policy guidance, there is not a requirement for the provision of or a financial contribution for affordable housing. The fourth reason for refusal related to the rat running issue. The issue on this point is that members were informed that the protection of the residential users, existing residential users of Adderley Place from the appeal proposal residents using it as a rat run could be secured by a condition. Members did not accept that advice, and reason for refusal 4 reflected the position of members on that issue. To respond, the appellant devised the Adderley Place Vehicle Discouragement Scheme. That scheme clearly demonstrates that the advice given to members that the matter could be dealt with by condition was obviously correct. The scheme is appended to the Statement of Common Ground and then states at paragraph 1.62, that's the Statement of Common Ground, that subject to agreed conditions, quote, the Council does not intend to submit any further evidence in relation to this reason for refusal, and the reason for refusal is withdrawn. Then turn to the planning balance. The appellant's case is that the site is allocated and the statutory development plan is up to date. As such, paragraph 11C of National Planning Policy Framework is engaged and the development proposals should be approved, quote, without delay. The appellant does not consider that there are other material considerations that should indicate the determination of the appeal application other than by approval. Indeed, the appellant, in looking to other material considerations, is able to identify that the material considerations are in fact positive in the planning balance. These include delivery of 92 dwellings in accordance with a plan-led proposal, the timely delivery and a mechanism to secure access to the balance of the allocation that lies within the Council's ownership, delivery of a high-quality housing development with a range of house types that will be attractive to a broad section of the community, energy-efficient homes built to exceed current building regulation standards, delivery of a policy and now statutory requirement for biodiversity net gain. In addition, there will be off-site tree planting secured through the planning obligation that will provide biodiversity benefits in excess of 11%, economic benefits associated with the construction phase of the development, and additional expenditure supporting local shops, services and facilities once occupied. The site is located in close proximity to shops and services promoting sustainable means of travel. A travel plan to encourage sustainable modes of transport is proposed, and provision is made within the layout to encourage cycling and walking. There will be an arboricultural benefit associated with the active management of retained trees on the site, together with new tree planting as proposed, and therefore I turn to the conclusion. So the appellant considers that there is a compelling case for planning permission in this case, associated with its allocation within an up-to-date local plan and the material benefits that it will deliver. And we will therefore invite you to allow the appeal in due course. Unless I can assist you further, those are my opening remarks.
Thank you, Mr. Morrison. I did allow you a little bit more time. I thought it was worthwhile if a hard copy to hear it in full, because it was an accurate record of
Thank you very much.
what was before me. I appreciate that. Has a written copy been provided to the appellant?
Yes, sir.
And has it been sent through to the case officer as well?
I'm not sure about that, but it will be.
I would just ask the parties to make sure that any evidence that's provided to me in excess of the inquiry document, this will be inquiry document number 4, is sent to the case officer.
Yes, sir.
Mr. Brown, so that the record can be kept with the inspector as well.
Yeah, the hard copy policy documents you've got, which we call document 3, have already got core document numbers. But I suppose it doesn't matter if we just record that they were handed in to you as well.
Thank you. I think what we will do, we'll record them separately as inquiry documents. So the core documents list is in place. Anything that's accepted during the inquiry will be referenced separately as an inquiry document. So for my record, we've currently got inquiry documents 1 to 4.
Yep, that's fine.
And that's how they'll be referenced in my decision as well.
No, that's perfectly clear, sir. Thank you. So then, yes, I will use a measured pace of delivery, so that those present who haven't got the benefit of a hard copy will be able to understand the council's position.
Thank you. It's appreciated.
Yeah. So this is the opening statement on behalf of the local planning authority. The planning application, which is now the subject of the appeal, was reported by officers to the Council's Planning Committee meeting on the 23rd of October 2023, with a recommendation that the committee grant planning permission. After hearing from their officers, the applicant and objectors, the committee resolved not to grant permission, but to refuse it. And 4 days later, the Council issued the formal decision notice. That notice is the formal decision of the Council, and it raised the following issues. Firstly, the impact on local air quality caused by increased traffic generated by the development, and that was the first reason for refusal. Secondly, the road safety impact of the proposed access to the A57, and that was the second reason. And then the third reason was in three parts. Firstly, the failure to achieve a policy-compliant level of affordable housing. Next, the failure to fully mitigate the loss of trees. And then finally, the failure to mitigate the loss of biodiversity. And then lastly, the fourth reason for refusal related to the risk to the users of Simonley Lane. The appeal was lodged on the 29th of February. On the 15th of March, the Planning Inspectorate issued its start date letter, setting in train the timetable leading to today's inquiry. In this appeal, planning officers had already given their professionally held opinion on the matters raised in the decision notice. They, that's to say the officers, plainly could not therefore offer the opposite opinion and support the members' decision notice in the appeal. By mid-April, the council had appointed a planning agent, Mr. O'Brien, who had agreed to act in the appeal as he felt professionally able to support the members' position. However, following further discussion with and advice from environmental health and transport professionals, he was not able to continue to support reasons for refusal 1 or 2. In respect of reason for refusal 4, the appellant designed a scheme that addressed the members' concerns. And following the submission of this scheme, Mr. O'Brien took the view that it was no longer to support reason for refusal 4 either. So on Monday, the 22nd of April 2024, the council's officers reported to the planning committee recommending that reasons for refusal 1, 2 and 4 not be pursued, and the committee agreed. The council filed its statement of case on the 24th of April 2024, and in it the council withdrew reasons for refusal 1, 2 and 4, noted that the appeal site was 2/3 of a larger local plan allocation under policy DS4, accepted the appellant's viability assessment as it applied to the proposed development on the appeal site, and it was agreed that £793,000 was available for Section 106 contributions for mitigation or off-site affordable housing contributions, but did not accept that it had been shown that a housing development on the wider allocation site could not viably deliver the required level of affordable housing and fully mitigate the loss of trees and biodiversity. The council's starting point was that when the site was allocated, the local plan evidence base was that it was viable. Without this evidence, the council did not accept that the benefits of the proposed development outweighed the harm to trees, biodiversity, and the failure to maximise the delivery of affordable housing from the allocation site. It was judged to be inherently probable that a scheme of 130 houses on the allocation site would be likely to be more profitable than 92 houses on the smaller application site, given that the access road infrastructure was largely common to both, and would therefore be likely to deliver increased affordable housing or environmental mitigation. The proposed development was therefore judged to be contrary to the development plan taken as a whole. On the 7th of May, the council informed the appellant that it was now satisfied with the further proposals to mitigate for the loss of biodiversity on the site, and that it would no longer rely on this element of reason for refusal 3. The main parties exchanged their proofs of evidence on the 21st of May. The appellant's viability evidence responded to the council's statement of case. It considered the council's case that the scheme could be more viable and therefore deliver more affordable housing or mitigation had the whole allocation site come forward, It concluded, taking into account increased building materials and finance costs, combined with a static or even slightly falling housing market, that not only would it not have been viable, a reassessment of the appeal proposal could result in the scheme being even less viable than it is now. The Council sent this evidence to its own viability consultants, retained from the planning application phase. On Thursday, the 6th of June, the consultants advised that they broadly agreed with the appellant's conclusions. In the light of his duties under the Royal Town Planning Institute Code of Conduct, and as an expert witness, to present only his true and professional opinion to the inquiry, the Council's planning witness, Mr. O'Brien, advised on the afternoon of Friday the 7th of June that he could no longer support reason for refusal 3, and that in his opinion, the planning balance now indicated allowing the appeal and granting planning permission. On Monday the 10th of June, after further internal discussion, the planning inspectorate and the appellants were informed of the new situation. As can be seen, throughout, the Council has followed national planning practice guidance and kept its case under regular review as part of active ongoing case management. The position is now this. Planning law and policy require that appeals are determined in accordance with the development plan unless other material considerations indicate otherwise. Applying that approach, as one must, leads inexorably to the following conclusions. The appeal site is on a wider parcel of land allocated for approximately 130 houses. In principle, therefore, the starting point is that housing is an acceptable form of development. Policy DS4 in the local plan requires that access is taken from the A57. The opportunities for doing so are limited to the relatively narrow gap between numbers 41 and 35 Dinting Vale. The Highway Authority has advised that the geometry of the proposed access in that location is safe and acceptable. However, the topography of the access, in particular the gradient of the slope, means that at present the Highway Authority have declined to adopt the access and estate roads. The Council does not advance this as a reason for refusal. Policy DS4 and CF6 seek to integrate development into existing transport networks. To the southwest of the appeal site is a network of public rights-of-way, including the Trans-Pennine Trail. A Section 106 sustainable travel contribution to link the appeal site to this network at Gamesley Sidings is proposed. However, this is going to need further discussion at the inquiry. You'll appreciate that I wrote this 24 hours ago when we're in a fast-moving position. Policy EQ5 requires that there should not be significant harm to biodiversity as a result of development. The Council is now satisfied that mitigation secured will result in this requirement being satisfied. Policy H4 seeks to maximise the delivery of affordable housing across the plan area. Policy H4 requires 30% affordable housing from the appeal proposal, but it also allows for a lower percentage where justified by a financial appraisal. And the appellant has shown the appeal proposal cannot viably deliver 30% affordable housing. The appellant has also now shown that the allocation site cannot deliver 30% affordable housing as the plan-making process assumed in 2014. It follows that there is no longer a sound reason to resist the appeal on the grounds of a lack of affordable housing, or prejudice to the delivery of affordable housing. Policy DS4 requires that mature trees on the allocation site be retained as part of a comprehensive landscaping plan that also delivers approximately 130 houses. Policy EQ9 requires that, where possible, trees that are removed as part of new development should be replaced at a ratio of 2 to 1. It's not possible to do so on the appeal site. Therefore, the appellant has agreed to make a financial contribution for off-site planting. It is not possible, for viability reasons, to make any further contribution, even though, which is disputed by the appellant, the 2 to 1 replacement ratio has not been achieved. This means that the only outstanding harm, which is disputed, is some unmitigated tree loss. The Council accepts that this level of harm is not sufficient to outweigh the benefits of delivering 92 market houses on land allocated for residential development in the adopted local plan. The Council's position in this matter was made public on the 14th of June and reported to the Council's Planning Committee on the 17th of June. And for these reasons, and for those set out in the signed Statement of Common Ground dated the 12th of June, the Council as local planning authority no longer resists this appeal. For the avoidance of any doubt, you, sir, must continue to conscientiously consider the objections of local interested parties. Thank you, sir. That's the opening on behalf of the Council.
Thank you, Mr. Richards. Like I say, I've noted that as inquiry document 4. I think that that's an appropriate time for us to now take a break. So I'm proposing to adjourn. We'll have a break of around about 20 minutes, which means we'll return promptly at 12 o'clock. That will give us around about an hour session to start with statements from interested parties and the public. I had allocated a little bit more time in the programme, but we've taken a little bit more time in this session. So it may be that we see where we are when we adjourn at 1 o'clock for lunch. It may be the case that, presuming witnesses don't have any constraints on, interested parties don't have any constraints on being in the room this afternoon, it may be there may be statements after lunch.
I do have to go back to school, unfortunately. I'm teaching this afternoon, but somebody is able to come and read is somebody able to come and do that for me tomorrow? Can I?
Well, there's the option. We'll be returning at 12. I'm happy to take you first at 12, notwithstanding what I'd said previously, if that works. Otherwise, someone can read your statement out tomorrow, should you wish to do so, or later, or during the session after the break.
I'll need to speak to school. Can I just make one point? The venue here is not ideal for local residents. I've had to take a morning from work this morning to be here. Had I been working locally, I work not far from the site and not far from my house, I would have been able to just nip out of work. Unfortunately, I can't do that here. And I would like to say that is representative of many residents.
I appreciate your concern, and I have seen those concerns previously. We did require a venue that was large enough, given the number of interested parties that was received. All I can say is that we've made the necessary arrangements, and I've made adjustments to time to give people the opportunity to come here. We do have written representations have been received and will be considered. And obviously, if people need the opportunity for others to read the statements, the opportunity is there to do so. I will reflect on the programme in terms of opportunities for statements to be made as necessary.
But if you wanted to gauge the strength of feeling from the community, you needed to hold it at least in the same county. This is not in the same county. And also, we've already been instructed, a select number of residents may be able to be at the site on Friday. You're kind of giving us a heads up there. Don't be there. So-
No. It's within reason for health and safety purposes in terms of people observing the site visit. That's it. All I can do is ask the council in terms of the constraints on the particular venue that we've got. But I can assure you that the written representations carry weight in the consideration. There are opportunities to read the statements, and we have adjusted the timings to make it easier for people to avoid rush hour to actually attend during the inquiry.
So you will know from your experience that public inquiries of this nature are very, very often held at the council offices. In this case, that would have been at Buxton. And the council appreciated the difficulty in local residents getting to and from Buxton. The council then spent many days trying to secure a venue in Glossop that was suitable in size and facilities. It could not do so. This venue was selected as being a much better option than holding the inquiry in Buxton. And therefore the council has done what it can to make the venue as accessible as possible to local residents. And I'm sorry if it doesn't suit everybody, but we have tried to make it better than it would be had we invited everybody to Buxton.
Thank you, Mr. Richards. Thank you, Ms. Bott. I've heard what you've said, and I appreciate the concerns that you've raised. And obviously, I understand the situation in terms of the inquiry. All I can say is that we have made the most flexibilities that we can do in terms of allowing access, and we'll review the programme should it be necessary to ensure anyone who wishes to contribute to the inquiry can do so. We are getting to the point that we do need to take a break. So it's 11:46. If everyone can return promptly for 12 o'clock. Thank you.
Thank you. The time's 12 o'clock, so it's now time to resume the inquiry. Before I invite statements from interested parties, just the pending matter, was there an opportunity to discuss between the appellant and the council with respect to the Facebook article?
I took the opportunity, sir, to discuss it with my learned friend, and it seems to me, sir, that it ought to be an inquiry document for no other reason that it's become into the public domain. I'm not saying, and I'm certainly not casting any aspersions on persons here present, but it's the sort of comment that's genuinely unhelpful at an inquiry. It doesn't help anybody's case when this sort of document circulates.
Thank you, Mr. Barrett. Is there anything from Mr. Richards on?
No, I can't really add anything. It says what it says. It's plainly a targeted invitation to park on the afternoon of Thursday the 20th. It doesn't take the brains of an archbishop to work out why. And I think your suggestion of a verification process, if I can call it that, is eminently sensible, which we would support.
Thank you. Yes, Miss Whittle? Miss Miskell, sorry.
Whittle and the engine, I believe.
Sorry. Occasionally I do get names wrong. So.
Yeah, I'm also aghast that this has been picked up on Facebook site, but for every comment like that, there are probably 200 comments which are valid in objection and a good point made against this proposal. And I'm also interested how you came by that information. You know, have you got spies out there? I'm just finding it interesting.
Through me, Mr. Miskell, please.
I find it interesting that local Facebook site's been trolled for adverse comments, and it's just one adverse comment in public.
Thank you. I do take the point. I think if we can, if it is, I'm happy to accept it as an inquiry document, but I think copies should be made available for anyone who wishes to view them as well. So if the appellant can prepare some hard copies and circulate them, so it's evidence that's before everyone, and I think because it is within my gift to undertake a visit at a different time, I will take that opportunity if I consider what I see isn't representative. So it isn't my place particularly to comment on who does what as part of an inquiry in their preparation and looking and access to social media, etc. Ultimately, it's in the public domain and it's been drawn to my attention. So I'm happy to receive it, and I appreciate the comments that I've received from all parties on it, and it'll be down to my judgment whether I consider what I'm seeing on Thursday as representative. The one thing I will say is I am familiar with the site. I have already visited it and I am familiar with it. So I will notice if it's noticeably different to what I've experienced in that area previously. And again, that may result in me doing further visits to understand. Mrs. Miskell?
If you would go to the site, could we just ask that it is at those times, that on school days where it's drop off and pick up times, be it another day?
Yes. No, my intention, the intention of the unaccompanied visits was because of the request to view at drop off and pick up time. So it's to understand that interaction in particular between local highway conditions and at the time of those periods, and also to look at it at peak traffic flows as well. Okay. Thank you. Mr. Barrett, I'll accept it as inquiry document 5 then, and if those copies can be circulated as soon as possible, lunchtime at the latest, please, to anyone who wishes to have a copy.
So I'll give you one, inquiry document 5. I think I gave one to that gentleman a minute ago, some time ago, and we've got 2. No. We've got 2 here.
Just through me, please, rather than.
I've got 2. We'll print some more off and put them at the back of the room.
Yeah, it's just for certainty, Mr. Barrett. Thank you very much. It's accepted as inquiry document 5, and I will review it in advance of the visit.
Yeah, I'm just reading it. I'm just saving it as that.
Thank you. Now, the intention is to move on to statements from interested parties at this particular moment. I hope everyone feels comfortable enough to sit up the front and provide their evidence there, and happy to take questions from both myself and presumably the appellant should they wish to do so. Just for clarity, obviously, everyone was sat through the first session there and the openings, and it's quite clear that the position that the council's set out now. But that does not alter the purpose of this inquiry and the opportunity for interested parties to make their comments. They will be taken into account. I will consider them, and it by no means leads to an inevitable outcome of the inquiry. It's like any other process in the circumstances. Interested parties have a role in this process, and I will consider any comments and evidence that's provided, and it will be given weight in due course in my considerations. So just in case anyone was wondering where that kind of leaves the process, because it does alter the inquiry, because there's not the formal cross-examination that you'd see of the individual parties where they're in dispute, but interested parties have a valuable role in the process regardless of that, and we're taking it into account, and that's the reason why I want to consider interested parties' views first, and then I'll hear the evidence from the appellant. Okay. Now, is there anyone with particular time constraints in terms where they need to be heard right now to bring them forward at the beginning, on the basis that if we've got around about an hour until 1 o'clock when I'd like to break for lunch, and it may be the possibility that if there are slight overruns, we may need to carry on hearing evidence after 2 p.m. No? Well, if that's the case, I'll take Councillor Gardner first. Are you happy to go first?
Yeah.
Ready when you are.
Yeah, morning everybody. My name is Stuart Gardner. I'm a ward councillor for Simonley, which obviously contains the proposed development. I'm also on the council's planning committee, but I have always recused myself when this proposal has come under a discussion due to my long-standing and public opposition to it. I mean, obviously there are many reasons why this proposal has attracted so much opposition and local concern, including the two major issues that the council were previously so worried about that they were asking for this appeal to be dismissed, namely the complete lack of affordable housing, which is contrary to the local plan policy, and the unacceptable loss of trees. Clearly very important issues, which I'm sure are going to be dealt with this week. But I just wanted to discuss a matter that, of all the many reasons to stop this development, I think should be in the forefront of people's minds. Access to the site from the A57, Dinting Vale. For background, I've lived in Simonley since 1999, 25 years. I know every inch of the place, and Dinting Vale is a traffic nightmare. Barely a day will go by when it isn't clogged with traffic, tailing back as it tries to get into Glossop and beyond onto the Snake Pass. The only access for the occupants of the 92 new dwellings in this proposal is from Dinting Vale. With most houses having at least 2 cars, that could mean hundreds of extra car journeys a day on the A57. Hundreds more car journeys a day on an already incredibly busy road. And where does the proposed new access road to the development emerge onto the A57? Opposite a primary school. Hundreds of extra car journeys a day near a primary school, in a place that's an air quality management area and where traffic projections suggest will get even busier when the Mottram bypass is eventually built. Would you want your child to go to Dinting Primary in those circumstances? More traffic, more air pollution, and a primary school. Not a good mix. And the proposed access road doesn't comply with adoptable standards. It would be a road with an unusually steep gradient dropping down to an already incredibly busy A road, the A57. Children on their way to and from school would face the prospect of trying to cross this new access road and avoid and get past cars pulling in, pulling out of it, possibly being driven at unusual speeds to cope with the gradient. It's a nightmare scenario and clearly would be very dangerous for pedestrians, many of them young children. You must surely see, you must surely know that that is unacceptable. And I guess what might be thrown at me is that I'm not a highways expert. No, I definitely am not a highways expert. But I have got eyes, and I've got 25 years of living in Simmerley. The development will make traffic worse on Dinting Vale. It has to. People of Glossop are rightly sick of the grind of traffic gridlock into and out of our town. I'd be astonished if there was anybody in our town who thought it was a good idea to build a development that worsened an already grim traffic situation on the A57. The proposal was unanimously opposed by the planning committee. It is fiercely opposed locally in Simmerley and in Dinting. Maybe the only people who don't have a problem with this development don't actually live anywhere near it. And so I implore you to dismiss this appeal and do what the planning committee did to this proposal, and that is throw it out. Thanks for your time.
Thank you, Mr. Gardner. Anything from
I do. Councillor Gardner, do you have access to the core documents? And if so, can you go to core documents 6.1?
I don't.
If you go on to the site that my learned friend mentioned at the start, Dinting Vale personal injury link, you'll find that you scroll down it, you'll get to the core documents.
Okay. If it's one or two documents you want, we could probably produce the hard copy.
The hard copy would be great. CD 6.1. Sorry?
Are there core documents by the side of the witness?
I don't know if it contains CD 6.1. It's the inspector's report into the local plan. Whilst that's being found, can I ask a question of fact of you, Councillor Gardner? You are a member of the Development Control Committee, and quite properly you said, I recuse myself from attending the committee. How long have you been on the Development Control Committee?
Only since I was elected for a second time, which was last year, 2023.
No secrets. The reason why I was asking that question was because I wanted to know to what extent, if at all, you had any input into the local plan.
No.
No. Right, I think it's being brought to you. As a member of the Development Control Committee, I've no doubt you've been told on many, many occasions that we are living in a plan-led system. Correct?
Yeah, please.
Yeah. So that to avoid ad hoc applications, off-the-cuff applications, a local planning authority is required to prepare a local plan to meet housing and other requirements for the foreseeable future. And it does that and then tests that by sending it to an independent inspector who independently appraises whether that document is justified and sound. Correct?
Okay.
No, I'm assuming that You'll have been told that. You're familiar with that.
Yes.
Yeah, okay. This is the inspector's report into the local plan. Now, you can see it's dated 24th March 2016. And I just want to ask you a couple of questions. If you go to paragraph 187, it's
Mr.
right
Mr.
to...
Barrett, can I just have a moment just to get there myself?
Oh, sorry. Okay. The version I had is a bit of an extract, sir. It's page 37 of the document. If you were working PDF.
Thank you. Just give the witness a moment to get there as well.
If somebody could help me find it, that would be great.
Yeah, it's page. Yeah, page. It spans page 37 and 38.
Do you have CD 6.1?
Oh, that doesn't appear to be the
doesn't look like it to
doesn't
me.
appear to be the right document. That.
Good.
187, please.
Yeah.
Thank you. Do you just need a moment to read it, Mr. Gardner, Councillor Gardner?
Okay.
And I want to draw a few obvious points from that. First obvious point, the council itself, in its capacity as local planning authority, was promoting this site, and indeed the appeal site is about 2/3 of the site that it was promoting, for approximately 130 dwellings.
Mm-hmm.
Correct?
That's right.
It was anticipating access from the A57. So it was anticipating 130 dwellings would access the site from the A57.
Yeah.
And the only location where that could occur is where the access is being proposed in this case.
Yeah.
Near the school.
Yeah.
Near the existing bus stop.
Terrible idea.
Sorry?
A terrible idea.
So terrible, in fact, that an inspector then had to apply his mind as to whether it was in fact a terrible idea and decide whether it was sound.
Yeah.
It's quite clear that a completely independent inspector referred to the junction with the A57 as a crucial issue. Correct? The conclusion of the inspector, and it was subject to a wildlife survey, not any additional highway matters, a wildlife survey, the site is sound. So, just pausing there for a moment, our starting point is that we've already tested this site in terms of the principle of residential development, haven't we?
It's on the local plan.
Yeah. It was tested, obviously, by the officers in the local plan in bringing it forward, tested then by an independent inspector, because you don't get away with, this is the council's decision, you're stuck with it. They've got to be able to persuade an independent inspector at a local plan process that it's justified and sound. Those are two of the tests that the inspector applies. And then when the application comes in, it's self-evidently less than the 130 dwellings that was being considered then, although there's still the council site to consider at some future stage. It's then subject to a further assessment by officers, not just officers of the council, but officers of the county council, who are the highway authority.
I know.
That looked a bit resigned.
Oh, yes.
Highway authorities who are independent and can be assumed to be expert in their field. This is their bread and butter job, testing suitability of access, etc. And they plainly do not object to the proposal.
Do any of them live locally, do you think?
Well, if they know their patch, that's their job.
Speak to anybody locally.
Can I just ask? It's questions, not.
Yeah, is this a statement? I don't understand.
So,
I'm not here.
Mr.
I'm
Gardner,
as a local
sorry.
resident, really. I
I follow that, Councillor.
I've been there
Miss-
25 years.
Miss-
I've realised. I understand why
Mr.
this could be
Gardner.
a terrible idea.
Mr. Gardner, sorry, just through me.
He's asking me questions, not you.
I understand. I was just saying to Mr. Barrett. Obviously, it's the form of a question, not a backward and forward necessarily. So if we can ask the question in the form where yes or no answer, please.
There's a degree of expertise that has to be brought, independence and expertise that has to be brought by the Highway Authority to making this judgment. It's its job, isn't it?
I agree, but why are we here if we're not allowed to make any comment about this? We're not experts. Nobody here is an expert in highways, but we live there and we see it every day.
I understand where you're coming from, Councillor, believe me, but shouldn't the expertise of an independent body whose job it is to assess this be given considerable weight in the decision?
So why are we here? Why are we speaking about
listen
it
to my
if
question.
whatever
I'm
we
saying,
say has no relevance whatsoever?
I didn't say, I have never said it's got no relevance.
We're not experts on highways.
Councillor, will you please listen to me? Their view should be given, and I'm putting to you these words,
More weight.
considerable weight.
There you go.
Their views.
Yeah. I mean, come and live in Simley for a week. You can have our spare room rent-free. See what you think.
Would please answer my question, Councillor? Their views should be given considerable weight. Do you agree, yes or no?
They should be given weight.
Yeah. And they should be given weight, not least of which, because one, it's independent, and two, it must carry with it expertise.
I think the views of people who've lived there and have lived there for many years deserves to carry weight as well.
Okay. Thank you, Councillor. I have no further questions. Thank you, sir.
Thank you very much.
Thank you, Councillor. Just,
Sorry.
So no, it's okay. I understand. Not familiar with the process. Thank you for answering the appellant's question. I only have one particular question. It's just in terms of the assertion that you make about the increase in traffic. Is that born of evidence that's specifically before me in terms of traffic generation that you wishing for me to refer to?
The actual the new link road bypass that is being built, the traffic surveys say there will be an increase in traffic along Dinting Vale, and they're just about to start work on that bypass or link road. And my point is, if you're going to have 92 new houses, the only way they can get there is via the A57. It surely makes sense that there will be an increase in traffic.
Yes. So I believe there was sensitivity testing undertaken in the transport assessment. I can't refer to the core document reference off the top of my head, but I believe what you're saying. From what I read, is broadly correct, but obviously we'll hear from the highway witness that there is an impact. What the impact isn't quantified though in terms of the precise numbers that might occur, and there is as far as I recall, there are qualifications to the transport assessment in terms of how the interpretation may be. But it was just for my understanding of the evidential base that I should refer to kind of underpin your point, as that may be. Yeah. I've no further questions, so I just thank you for giving your evidence.
Thanks for your time.
Yes,
thanks very much.
Thank you very much. Thank you. I said that Mr. Hardy, I'd take you last because you said you were going to focus on air quality. Trying to keep the highway evidence together. Mr. Bennett, is your point primarily around access? I understand from your introduction it was. So happy to take your evidence now if you're comfortable to do so.
Thank you, sir.
Are you happy to take questions from the appellant and myself?
Yes, certainly. Yes, if I can answer them, I will.
Thank you. Whenever you're ready, Mr. Bennett.
Well, thank you, sir. Good morning, everybody. My name's Dave Bennett. I'm a resident on Simondley Lane. I've lived there for 37 years. I'm also the chair of an organisation called High Peak Access, and we're a voluntary group, and we campaign for people to have better access to services and to facilities in High Peak, particularly disabled people. So if I could make comments on, with two hats on really, firstly as the chair of High Peak Access, and then secondly as a local resident on Simondley Lane. That's okay?
Yes.
So firstly, as a chair of High Peak Access, we are consulted by the Borough Council on planning applications where there is some impact on the access to a building or a service that might affect disabled people. So as a result of that, we were aware of this application, which is a major housing application and also involves some public open space. So we looked at it when it first came in, and we raised a number of concerns over the access and the amount of access that was being provided to the individual properties, because when High Peak Borough Council first issued their design guides and their local plan, they stated that they would want 100% access to ground floor for disabled people. And we noticed from this application that this fell way short of that. It was literally much less than 50%. So we raised objections, and as a result of that, the application was resubmitted, as I understand it. And we looked at it again, and we noted that the applicant had then managed to achieve just over 50%, which is in accordance with the council's current expectations following a report that they had produced on the actual accessibility of properties. Now that still falls short of, in our opinion, 100%, which is what we would advocate. But we've noted that they've actually complied with the council's requirements. Now, I hadn't until this morning seen details of the physical access onto the site that was proposed from the A57 for pedestrians in particular, or for disabled people. But I do note from the proposals that have been made that actually, whilst the developer has tried to achieve something like 1 in 20 gradients on the footpath element, it looks to me as if that footpath would not comply with British Standard 83000 in terms of its design to be able to allow reasonable access for someone who was using a wheelchair. So that is a concern that I have now in respect of that. And secondly, as a resident now, I've lived in Simondley for 37 years. I've seen the traffic increase over the years dramatically with the developments that have happened in Simondley primarily, really, and the impact that that has had on the traffic on Simondley Lane in particular. And I am very concerned about the access from Simondley Lane along the unadopted road to Adderley Place, and the impact that a rat run would have on the access onto Simondley Lane because of the difficulties of getting onto the A57 direct. And I think that that would mean that people would, for preference, use Adderley Place onto Simondley Lane as an alternative, and they would then go up Simondley Lane and over something called High Lane, which drops down into Charlesworth, which is a very small hamlet, which has its own issues on a daily basis of people from Simondley doing that. And that would only be made worse by these properties being built and if that rat run was used. As an alternative, people would then come along Adderley Place and turn left and then join the A57 at a mini roundabout and join the queue, basically, because it's a queue on a daily basis. And I've only just seen this morning the proposals that have been put forward by the applicant or the appellant to mitigate the possibility of it being used as a rat run. And I have to say, I'm not convinced by the design. I would have to look more closely at the detail, but it seems to be suggesting to me that there would be some bollards put up, which may or may not restrict cars from going down Adderley Place. But the residents of Adderley Place have the right of access down Adderley Place onto Simmonsley Lane. There aren't many residents. I don't know how many exactly, but we're only talking about perhaps 6 or 7 properties. And they would still have to be able to have access down. So I don't see how a bollard solution, unless those bollards had to be removed by the residents themselves and then put up again, how that would work. If there's a restriction in width, then if a resident's car from Adderley Place can get down, then I presume a car from any of the new properties will be able to get past as well. So I don't see how it would work. And I haven't had a chance to have a look at those in detail, but I'm concerned about that as well. I also note in that same report that there was a suggestion that pedestrians who wanted to access the new development could do so via the public footpath from Simmonsley Lane along Adderley Place, which anybody is perfectly entitled to do. But there was a suggestion that that would also be accessible for wheelchair users, and it clearly isn't. The access close to the junction with Simmonsley Lane is far too steep. It is a cobbled access, which is totally unsuitable for wheelchair users. And so without some form of work in that area, it would not be suitable for an alternative pedestrian or wheelchair access onto the new site. So, as I say, I've lived on the lane for many years. I've seen the traffic increase, and certainly to make this site in any way accessible to Simmonsley Lane would actually result in further disruption to an already very difficult access onto Simmonsley Lane. It's not an access which would be approved under any highway engineer's remit now because of the visibility splays and the lack of visibility. So I don't think it could be made to be suitable for 92 properties to have access from there. And I'd also just like to say that I'd like to reiterate the comments of the woman who's now left, unfortunately, that this venue is totally unsuitable for Glossop residents to have to get to be able to appear at this inquiry. I do know that Dinting Church was offered as an alternative venue, and it was refused. I think perhaps one of the reasons that it was refused, and it may relate to the regulations of the Planning Inspectorate, that it wasn't suitable because it didn't have the required number of retiring rooms or facilities. So I think it's an issue that the Planning Inspectorate should look at, because to hold planning inquiries that actually impact on residents' lives in venues which are totally inappropriate is an abuse of the system, really. And I would like to note that. I did attend a planning inquiry in Buxton last year, and it was held in the Octagon, and we deemed that to be unacceptable as well, because the actual facilities weren't suitable. At least here, there's a hearing loop, there's a PA system. None of that was available at the last inquiry that I attended, and we objected to that. And the council obviously have taken some note of that. But to come up with this as a venue as an alternative for a scheme in Glossop, I think is just shameful, really. Thank you.
Thank you, Mr. Bennett. I have noted your comments on it. Obviously, I've asked the council to respond on that, and and we'll look at the programme. All I can say from my perspective is the level of public interest, as far as I'm aware, there wasn't a venue of a suitable size that could have accommodated the residents who may have wished to attend and to speak now. But I will note it, and I will pass it on as well in terms of inquiry procedures. Thank you. Just before I invite invite the appellant to ask any questions. The only query I've got initially is whether British Standard, is it 8,300?
8,300.
8,300. Whether I don't know whether that's a core document. So would it be possible? Would it be possible to obtain a copy and to add it as an inquiry document, given it's been referred to?
Yes, he says confidently, not being the person who'll be responsible for finding it, but I'm sure that, and I've no reason to doubt that Mr. Bennett has given us the wrong BS number. Perhaps before he goes, he might even help me when we break for lunch to look over my shoulder while I Google it and try and find it for downloading.
I will, yes.
Thank you very much.
Thank you. Mr. Barrett, any questions?
Just a few. Good afternoon, Mr. Bennett.
Afternoon.
Mr. Bennett, we'll have to deal with the British Standard point out of the inquiry, but there's a couple of matters. You are high peak access, is that correct?
Well,
but you are a representative of high peak access.
Yes, I'm the chair of High Peak Access. We're a voluntary group.
Yeah. I'd like you to look at a document which is the officers' report, CD 3.1.
Just wait for a copy to be...
And there's a real problem with this because it would be much easier if you had a PDF copy, because the officers' report, I don't think, is paginated. But those of us looking at a computer and a PDF copy will find it at page 25 of 85. Can I ask you to use your computer, Niall? Is that okay? Mr. Mellon, who's my instructing professional, can give you an extract from it. But if you actually want to look at the document, if you're looking at the PDF page...
Nicola, we found it. He's going to have a screen.
I think the problem is because I'd have to ask him to count 25 pages into the document. Do you see that?
Yes, I do.
And you'll see this is a summary of the consultation responses that were made. And yours is there. As you mentioned a moment ago, you requested that the development be revised to demonstrate compliance with building regulations. That's disability access, isn't it, M4?
That's right, yes.
To meet the requirements of the local plan policy as well. And that was done, and you'll see the words now resolved.
Yes.
Can I ask you this other question? I don't know if it was you or a colleague of yours in High Peak Access that did the response, but of course you were responding not to an outline application, but to a detailed planning application that showed the details of the access. It would have been quite obvious that the access was on the A57, and that there was a proposal, well, the initial proposal was for 100, and then it was reduced to 92, wasn't it?
Yes.
So whoever responded to this didn't seem to take any particular issue with access onto the A57, traffic generation from initially 100 vehicles, now 92, must have been familiar with the area, as you have said you are familiar with the area, must have known the likely steepness of any gradient to get from the A57 up to the other public right-of-way.
Well, through you, sir, yes, that's right. In fact, we're confusing two issues here. So I just need to explain that actually the reference to compliance with building regulations M42 is in respect of the detailed design within the dwellings.
Yes.
Not the access to the dwellings, necessarily. And the HEL note, which is the document I referred to, is housing needs and local economic assessment, and that refers to the number of dwellings that should be to M42 standard.
Yeah.
And I think, as I said before, that now achieves just over 50%.
Yeah.
We made the point at the time that we felt that the local council, in actually undertaking this HELNA assessment without any consultation with the wider public, we weren't consulted on that document. And it's that document that reduced the requirement for M42 standard from 100% to 50%. We weren't consulted on that. We would have objected to that if we had been consulted. And basically what we have said is that on the basis of the current requirements that the council is working to within the HELNA, we accept that the dwellings as now proposed have a just over 50% requirement for M42 standard. We did not at that stage have detailed access to the document that I've literally just seen this morning, which showed a footpath access going from the A57 up to the main development and the gradients that are proposed on that footpath access. I've only just seen that document this morning.
Okay. Not sure that that must necessarily follow, but certainly the relationship of the development to Adderley Place would have been apparent from considering the application. I understand your point about wheelchair access. I've got that point.
I think this is one of the issues with the development site being designated as suitable for housing going back to the local plan in 2016. I think if there had been a detailed appraisal of the access requirements from the A57 to achieve a developable site within that area, then it would have been recognised at that point that this site wasn't really suitable for housing. And a point which I haven't actually made, but which I would reiterate from the comments that have been made, if this site was a properly developable site, then we would have had affordable housing achieved on that site. And we haven't had affordable housing achieved on that site. I think because of the inherent costs of the development of this site, because of the topography and the difficulties.
Can I return? We will deal with viability later on. But I do want to pursue this point about the relationship between the existing development and the A57. There had to be a connection. The two fixed points that must have been apparent to anybody considering this site, in principle, is the position of the A57, which is not going to change, and the position of the existing right-of-way at the top of the site, and there had to be a connection between the two.
That's right.
And anybody, and I have in mind that the inspector who considered this in the round is both a qualified town planner and is a member of the Institution of Highways and Transport. So one would expect a reasonably experienced, as they always are, inspectors dealing with a local plan, to be able to recognise that. I mean, he's not going to get a tape measure out, but he's going to recognise that that's going to be a gradient that has to be overcome, isn't it?
Well, it would be interesting to go back to 2016 and analyse the effort that was made to actually look at this site in detail. I suspect that there was not the sort of analysis that you're talking about done when the site was first considered. And I mean, I was a chartered building surveyor. I'm used to looking at levels, but I myself, because of the nature of the ground in that area, cannot ascertain, because of the amount of tree growth, the amount of foliage in that area, it's very difficult to ascertain the true gradient between the level of Adderley Place and of the A57.
Thank you, Mr. Bennett. I have no further questions. Thank you, sir.
Mr. Bennett, I've just got a question regarding the access onto Simmerley Lane. Sorry. The access on. My question is in relation to the access onto Simmerley Lane that you referred to. I am familiar and I have walked the route. You say that it's an unsafe access because of visibility, and I have observed, and I will observe again as part of site visits, the access from Simmerley Lane onto it leading down to the A57. But just an understanding, I noticed there was a scout hut on the cobbled section of road. Are you aware of any evidence of the kind of traffic movements and any issues arising from the use of the scout hut? I know obviously I'm not looking at a like-for-like comparison. It's just an understanding of local knowledge of the kind of vehicle movements that take place along that route typically.
Yes, well, I mean, I don't walk that route every day. I used to be a dog walker and walk it very regularly every day. And certainly from my experience, the actual traffic flow to and from the Scout Hut is fairly minimal, really. A lot of the people who use that Scout Hut live locally. So the scouts or children will walk up and down the lane and they'll walk to the site. They'll walk to the Scout Hut itself. Certainly the amount of traffic that would be there, unless there is a one-off special occasion, because they do hire it out, for example, but very infrequently because it's so well used. There tend to be not so many cars going up and down Adderley Place to get to the Scout Hut.
Thank you, Mr. Bennett. I have no further questions. Thanks for your evidence.
Thank you.
Right, we're approaching just after quarter to one, so I've probably got time for one further witness before we break for lunch. Mr. Hardy, would you be happy to present your evidence after lunch?
Yeah,
sorry, Councillor Hardy, yes. I'll take Mr. Miskell in that case, if you're happy to give your evidence now, please.
May I start?
Yes.
In opening, I would like to thank the panel for affording me this opportunity to speak today, but it is disappointing that the venue, need to reiterate it, could not be made available in Glossop. This location has made it difficult for those wishing to attend due to transport issues, work and family commitments. I may add that had the venue been in Glossop, the inspector may have witnessed the effects of ever-increasing development and resulting traffic volumes has on an infrastructure designed but not updated since Victorian times. I only learned this morning, so this is a rushed statement, that the council had decided to drop all the issues regarding the reasons for the initial rejection. So I'm going to skip this bit because it'd be saying that we were having council support. On paper, Wayne Holmes gives the impression all aspects of the development now look rosy, but the reality, and I repeat, the reality for the wider community will be totally different. In being that parents who currently conduct 2 school runs because they cannot get their children into the same school, parents who are concerned about the safety and health of children attending Dinting Primary School, the mitigation is to provide funding for monitoring of air quality, but it does actually nothing to improve it. And in the appellant's counter-argument, they do admit that the development will add to those levels. There's also the issues of the burden, the extra burden on local health facilities. There used to be a 2-year waiting list up until recently to get on a dentist's books. We're now finding that there's no chance of getting on a dentist's books now. People are having to go into Manchester trying to get medical attention there. Also, as well, doctor's appointments we're finding now over the last 2 years they're becoming more protracted, where you could ring up and probably get a doctor's appointment the same day or even in a couple of days. On occasion, people have been asked to wait 2 weeks for the first available slot. Affordable housing. A major goal of the local plan was to provide affordable homes for local young families and workers so they did not have to go outside the borough to seek homes. To permit this development without the 30% allocation for affordable housing totally fails those families, and the proposed 106 is an insult to those families who bought into the concept of the local plan. The council has declared a climate and subsequently a wildlife emergency. This development, if approved, flies in the face of both declarations. The site promotes car use. No one will carry a heavy weekly shop back from the shop School runs are inevitable as nearby schools will be near full or fully subscribed with the number of current developments as they come onto the market. Pressure on highways capacity at peak times will be increased at a section of a primary route network, the A57, renowned for standing traffic and can only add to the carbon emissions, thus reducing air quality and potentially increase the danger of school children coming into conflict with traffic when attending Dinting School. Contrary to the transport plan, people of impaired mobility will struggle to access the Dinting station or even the development due to the gradients encountered. The section of the A57 is known for not being cyclist friendly, nor does it promote a safe environment for its undertaking. Air quality, annual mean tube readings cited within the AQMA, which have been questioned and reasoned they cannot be accurately established due to the reduced traffic during the COVID pandemic, but other factors have not been taken into account. The 20-week gas main upgrade on the A57 Mottram Moor, the closure and ongoing restrictions on the A57 Snake Pass due to subsidence, and the almost monthly upgrade of utility services on the A57, all of which cause drivers to seek alternative routes in or out of Glossop, and ultimately would affect those levels being recorded. Wildlife. The site is a habitat for a species of bee. Its numbers have decreased nationally by 92%. Red-listed bird species, with barn owls and rare flora only found on Ancient Meadow, all to be ripped up and purportedly replicated off-site to the benefit of people outside the ward in another town. A loss of open space that has been enjoyed by locals for decades. Footpath 50. Residents' legal right of unrestricted access over the footpath, the only means of access to their homes and that of emergency services, have been ignored with no consultation whatsoever regarding the crossing point. It cannot be constructed without obstruction, and as one resident put it, fires do not wait for a vehicle to be removed or a barrier to be taken down. I may also emphasise that at no stage has the wider community been consulted regarding any proposal pertaining to the development. I ask that the delegated inspector during his site visit considers carefully the proximity and dimensions of the access, the grading involved to the development and Dinting station, and where the bus stop will be moved to without affecting sightlines. Ideal is to get a complete understanding of local issues. He should make arrangements to visit the site during proposed drop-off or pick-up times. Consultation prior to the adopted local plan 2016 drew significant opposition to the inclusion of Adderley Place. 10 years on, that feeling is not abated, evidenced in the significant number of 440 plus objections to the initial application and a petition post-appeal that attracted 500 signatures in its first week, now stands at 853. Objections from across the Glossop community because they experienced the reality. The decision to refuse the application was welcomed by the greater Glossop community, but if the decision is overturned, then where is the democracy and the respect for the views and concerns of the people of Glossop? In all seriousness, if the decision on an elected development control committee cannot carry authority, then if I was on that committee, I would seriously consider resigning. Basically, that's it.
Thank you, Mr. Miskell. Mr. Barrett, have you got any questions?
A couple of points, Mr. Miskell. There is, in fact, at the request of the Derby and Derbyshire NHS Integrated Care Board, there was a request for a contribution. The provision that will be made in this case is not precisely what was asked for, but a £40,000 contribution to provide additional healthcare capacity. Were you aware of that?
I believe the initial figure, or if I'm correct, offered by the appellant was reduced to 26,000.
Well, what?
As I say, there is a problem for the wider public to access any document via the portal. It's hit and miss. I've just had someone ring me this morning saying they've tried to access said documents as regards the this appeal, and they're struggling.
Oh, I
as regards 106 agreements.
The document that I'm asking you about is, and the figures that I'm asking you about appear in the officer's report, so that's some time ago.
Right.
And for the inspector's note, it appears at page
Right.
58.
But you have to
of
appreciate,
85.
you know, I'm a layman.
No,
you
I
know.
understand that, Mr. Miskell, but
The amount of documents which were supplied post-decision process actually dumbfounded a lot of people. They haven't got that time, that acumen, in my case, the education, to go through them and itemise each detail. But what I do know is a lot of the documents I've read, as regards to the data finally arrived at, or the result, the council questioned the figures. They thought they were too low in the case of trip counters. In the case of Derbyshire Wildlife Trust, the metric used as regards arriving at the BNG was questionable. And that you can see that time and time in the document. You know, as an objector, that's something I obviously pick out on.
yeah, Mr. Miskell, that actually helps my case, and I'll explain it.
Yeah, it probably does.
Because when the
I mean, obviously, you know.
please let me finish my question.
Yes, Mr.
Because
Miskell,
when
don't interrupt,
council's independent officers say, well, and the Derbyshire Wildlife Trust, for example, who are not part of the council, say, we're not happy with this assessment. We're troubled by your calculation of traffic generation, the Highway Authority. My client's case is then being tested. Their evidence is being tested. The expertise of their consultants is being tested. But by a process of engagement, for example, on traffic generation, that is my clients, went off and demonstrated that the assumptions that went into that were based upon empirical data from comparable sites, at which point the council agreed. Once the evidence was tested and challenged, we went back, you're absolutely right, they were not satisfied initially, but they were satisfied subsequently because we had to prove the case. And that's why I say it helps my client's case, doesn't it? It wasn't a case where the council just threw up a bunch of papers and said, oh, we have to agree with the appellant. Exactly the opposite. They didn't agree with the appellants on lots of issues, and we had to prove our case. Now, doesn't that assist, do you think?
Yes, it does
with
assist, but, you know, it gives me the impression that the appellant has to be brought screaming and kicking to arrive at the final data. It's like we've had to drag that information out of them.
No,
not me, but the council,
it wasn't,
or the relevant bodies.
The information was already provided. The information that was challenged, they were saying that assumption is wrong, or the evidence.
But we're talking about people with expertise, so should that information not have been correct in the first instance?
It was correct. It explained it. The council then, highway engineers, and this is just one example of many, said we're not entirely comfortable with that. Will you please go and demonstrate to us why that assumption is correct? And when we do that, they're happy. Happy may not be the correct word. They're content.
Well, content. But, you know, a lot of this information is based on desktop exercises. And you can get a result from that. But without actually going out there and physically viewing the site, you would get a totally different picture. It's like highways. They've not been invited, as big as this development is, they've not been invited down to actually view the access. He's done it on a desk somewhere in Matlock and come up with the assumption. As regards the gradients, you need to stand there. Like Dave said, they're not immediately obvious on a topographical chart. If you go down there and stand on the 8, well, better off, go onto the footpath 50 and look down to the A57, you will get a real idea of.
Are you giving positive evidence that the highway engineers of the county council never visited this site?
Yeah,
are you saying that they never visited?
I believe the request that the Development Control Committee was for highways to come out from Derbyshire County Council. I might be incorrect, but I believe the response was highways have agreed to it. There's no need for them to come out. But I think, you know, to cover all bases, I think it would be fair to invite an engineer down from Derbyshire County Council to come down and look at the access, look at the gradients involved, take into account the traffic problems we've got, and make an assumption on that. If it's all kosher, hunky-dory, and right across the board, he'll have no problems with it. So, I just find, I'm absolutely gobsmacked that he's not been invited out in the first place. Well, he's not been down to see it.
It's a matter for the Highways Authority, and I've seen no evidence that they didn't attend. But let me put this to you. it must mean, mustn't it, Mr. Miskell, that there's a consensus of views of at least two highway engineers, and I say at least two because there's a consultation response from the Highway Authority and there's the appellant's own evidence, that were satisfied as experienced engineers that this access was safe and workable.
Right. Well, to counter that argument, back in 2014, 2015, residents employed an independent highways engineer to come out and look at the access to Simmerley Lane, which he agreed the visibility displays could not be achieved. And he also gave a detailed report, and I think I've put that report to the inspectorate, regarding the access on the A57, which would require some form of hierarchy, i.e. an extra lane to allow traffic coming into Glossop to do a right turn into the development, proposed development. Recently, another engineer's been out, and I'm hoping he will come down here and speak on behalf of the residents, and he's come up with the same view, that this access, as it stands, is not adequate. Not for the volume of the traffic it's expected to take.
The engineer...
Like Stuart, well, Mr. Garner pointed out, the trip counts, have they really been taken into account? We're talking 200 vehicles in and out. Peak times, morning and afternoon. But then on top of that, you've got delivery vans. Everyone seems to get the shopping now via online. Residents having guests coming in and out. It's just going to be non-stop. And I kid you not, maybe you need to come down and look at the traffic volumes in the morning. So if you're trying to do a right-hand turn from that estate to go east to your place of work, you're relying on the traffic going west to let you out, and then you've got to manoeuvre onto the opposite lane and hope that they let you, that they stop to let you travel east. It's an absolute nightmare. When you live there, it's free.
I'm sorry to interrupt you, but let's try and focus on a couple of questions.
All right.
You said you had an engineer come out and look at this. Was that provided to the council as part of your objection, to your knowledge?
It wasn't an objection, it was during the consultation period, and he supplied a full report to that consultation, highlighting all the points.
Right. And
therefore
it must follow, mustn't it, that the concerns expressed by him were taken into account?
Well, you could say, yeah, were they taken into account and were they ignored? I don't know.
Well,
there was never actually I've never actually seen any feedback.
They must have been aware of them.
I've never been aware of any feedback from the council as regards the comments supplied by that engineer.
They must have been aware of them, mustn't they, Mr. Miskell?
Well, yeah, I agree with that. Yeah. But there again, if we're talking about them being aware at that time, was the inspector who made the comment back in 2016, did he do a site visit? Was he privy to all the topographical charts? Did he actually come down and look at the site and look at the gradients between the A57 and the footpath? Also, as well, the trip counters back then would be totally different to the levels of traffic we're getting today. We're talking about 2016. I've lived in Glossop now for nigh on, 15 years. And I know for a fact, since 2016 to the current day, year on year, to travel, quarter of a mile down that road, it's like 10 minutes added every year. Now, at the time, the inspector noted that the access is in the local plan, but he's also recognised the difficulties, but he said they're not insurmountable. Well, I agree with that. Nothing's insurmountable if you're prepared to throw enough money at it. But also, as well, at that time, well, we're talking, what was the date, 2014, 2015? Yeah. It was not an AQMA. The AQMA was declared in 2019. So in that period, something has gone wrong between the time of the proposal for the local plan to 2019, which has increased levels dramatically. And as regards levels now, as I've stated, are they accurate? We've got an ongoing situation now where the A57, Snake Pass, is under restrictions. It stops heavy goods vehicles from travelling over it due to subsidence. We also had a 20-week period, as I stated, where the gas main upgrade on Mottram Moor made drivers or people going to work leave the A57 in droves. People going west would not come down, use the Snake Pass at that time. What they did do was go east over Tintwistle. And funnily enough, it'd be interesting to see that there was an NO2 spike at Tintwistle above the permitted 40 NG levels. Does that actually coincide with the gas works?
Mr. Miskell, I'm not going to speculate on what you are speculating upon.
I can only speculate, like I say. I'm not privy to all the figures.
You referenced the NOx.
But I'm going off experience. I live in the town.
Sorry, Mr. Miskell. One at a time, please.
Right.
It's only helpful to me if I hear the answer and
right.
the question.
We
Mr.
must
Barrett?
proceed upon evidence. And I'm going to put to you that there is therefore a consensus of informed opinion in two competent, experienced bodies that deal on a day-to-day basis with access arrangements, safety, ensuring that safety is properly considered at the time of the application. Informed expert opinion is that this is satisfactory, isn't it? You may not like it, you may not agree with it, but that's the factual position, isn't it, Mr. Miskell?
But we live with the result.
Sorry?
It's a desktop exercise. It looks great on paper. In line with councillor Gardner's, we live it, we experience it day out. I used to be going into work late on a daily basis, explaining to my bosses, I live in Glossop, the traffic's that bad. That was back in 2015.
Thank you very much, Mr. Miskell.
No,
I've no
sorry.
further questions.
As regards education, they're saying there's enough places. Well, on paper, government reports. It's not realistic.
Thank you, Mr. Miskell. I've got the point, and
Right.
Mr. Barrett's got his answer. I believe the evidence that you've given and the questions that are asked. I don't have any specific questions. I just reaffirm to you that I am aware of the strength of interest locally, and you've specifically referred to the 440 plus objections and the petition, and I have got that, and I will take it into account. So I just thank you for the presentation of your evidence.
Well, I apologise if I
Thank you.
sounded a bit aerated, but I live in Glossop. These people don't.
I understand the strength of feeling, Mr. Miskell, and thank you for your evidence that you've given.
I'll just pinch this glass.
Thank you. We're a little bit after 1, so I'm proposing now if we can just break for lunch. So, Councillor Hardy, if you're happy, and we'll resume at 2 p.m. For you to, and then I'll invite you in to present your evidence once we deal with some housekeeping matters. Right. The time's 1:08. The inquiry is adjourned until 2 p.m. Thank you. Thank you. It's 2 o'clock, so if everyone can just take the seats, we'll be resuming in a moment. Right, it's just after 2, and the inquiry is resumed. So, before this morning during the openings, mentioned about the note, and you said after lunch you'd have a update. Is there anything on that particular point, or do you need a little bit of time?
The note is being drafted over lunchtime. As I understand it, a happy consensus as to its content has been reached, and you'll be getting it shortly.
Yeah. Next break?
Yes.
Certainly, yeah.
If you've been looking at the inquiry webpage over the lunch break, you will now see that inquiry documents 1 to 5 have been uploaded.
Thank you. Incredibly right.
Yeah, well, thank you very much to the council's good offices, and I guess that when we get it, we'll upload the note.
Thank you.
Which will be inquiry document 6.
Yes, it'll be in 7.
7.
7, because I think there was the British Standard document that was going to be.
I have news on that. We will not be able to assist Mr. Bennett with producing that, not least because it costs £238 to download it.
Okay.
So if Mr. Bennett is to produce it, or even extracts from it, I'm afraid he will be. We will assist him scanning it into a PDF document or whatever, but he'll need to produce the original.
Mr. Bennett, is that something that you'd like to produce or put before me to allow me to consider?
Yeah, I think I'll be able to bring it tomorrow morning, sir.
Okay,
So I might be able to help. I raised this with Mr. Roberts, and Mr. Roberts said there's actually a bespoke. I think it's Highways Institute. Yeah, there's a bespoke document that postdates the British Standard and refers to the British Standard as the document to use in terms of accessibility for the disabled and others. I don't know if you're familiar with it. It's called Inclusive Mobility from the Department of Transport, a guide to best practice on access to pedestrian and transport infrastructure.
Oh, right, okay.
So it refers to the British Standard and doesn't cost £230 to print it off.
I've actually got a physical copy of it.
Well, we'll reserve ID 6.
Okay.
Or something relating to inclusive mobility.
Yeah.
Whether it's the Department for Transport document or whether it's BS 83.
Yes, the one thing that I may suggest that might help us along is the Highways Institute document. Before looking at it, if you could maybe during the next break, if Mr. Bennett wouldn't mind taking a look at it and to see what his views are, and we if agreeable, we may accept that document. If Mr. Bennett thinks it needs to be supplemented by the British Standard, then I'd be happy to consider that as well.
Yeah, I'll have to leave at 3 o'clock. That's my only.
Yeah, no, we will. We will be hopefully taking a break at some point, or alternatively, we can deal with it tomorrow morning if need be. If you're back again, then Mr. Bennett. So I'll leave it in the hands of the part underneath. Given the amount of representations that's made, that there's a lot of people that share those views. So I hope that people take that as people being a spokesperson. I hope that anyone who attends tomorrow, they'll have the opportunity to also make their voices heard. But don't think for any reason when I go away at the end of the inquiry that I'm thinking, there's 20 people, that's representative of the strength of feeling that with the application. There's a lot of written correspondence that I'm also taking into account, and I understand the level of feeling. So I do understand your concerns, but a venue closer to the site and the potential issues of not being able to accommodate enough people who did want to speak, given the 440 objections and the 800 signatures, it was necessary to find a venue large enough to accommodate people. And I understand the concerns that have been expressed about that. But I hope the fact of anyone speaking in the role of a spokesperson and your assurances from me that I understand that strength of feeling at least mitigates it to some degree, even if not completely. Okay? Mr. Hardy. Sorry, it's Councillor Hardy. Is that fine? No, I don't want to. I don't want to address you in the wrong way. Thank you. Whenever you're ready, as you may have seen with the witnesses this morning, there is the opportunity for questions. It is helpful to me that I hear the questions and the answers. I can show you the sheet effectively. I tend to write the question down that's asked, and then I write the answer. So when I've intervened this morning, that's the purpose. When it's a conversation flowing between the barrister and the interested party giving evidence, it makes it more difficult for me. So if I do intervene and just ask you to pause, it's not because I don't want to hear what you've got to say. It's because I need to get an accurate record of what's been said. And that's just to reaffirm in terms of how the proceedings were this morning. It isn't in any way to kind of stop you making your point. It's that I can record it, really. Okay.
Thank you very much. Do I just press this to turn it on? Is that right?
No, it's when it's upright that it's on.
Right, fine, thank you. My name's Paul Hardy. I'm a councillor for Old Glossop, which is sort of 3 miles away from the site. I've lived in Glossopdale for 71 years now, and I've lived in Simonley for 45 of those years, albeit in different houses. We now live on Simonley Lane. We've been on Simonley Lane for 9 years, and over that 9 years the traffic has increased probably double, and that's not speculation. I mean, you might turn around and say, well, it is speculation, you haven't monitored it. I don't have to monitor it. It shakes my bed every 2 minutes, and honestly it's just been ridiculous, the actual volume in traffic, the increase over the years. I'm not a NIMBY. I don't mind houses being built anywhere in Glossop or Hadfield or Chinley or Chapel or Birmingham. Doesn't matter to me where they're built, as long as they're built in a way that doesn't affect the residents of those areas and is a benefit to society. Am I allowed to ask one of the experts a question? Can I do that now?
You can't. Not in your presentation of evidence, but you will have an opportunity when they're giving evidence to ask
I
that
might
question.
not be here.
Or you can leave the question hanging in the air, and I'll ask it through.
Right.
You can ask it through me.
Okay, that's fine. Thank you very much. I've got the. Well, first of all, I don't think anybody here, and if they do, I think they're lying, would not admit that exhaust fumes cause harm to people. I don't think anybody here, the experts, the barristers, solicitors, the developers, I don't think anybody here would turn around and say exhaust fumes aren't harmful to people. Another scenario, I mean, you might laugh at this, and I don't really care if you do, because I've got a grandson, he's 14 now. He comes to our house twice a week. I'm very lucky, I've got a very modest 4-bedroom detached house on Simonley Lane, and those houses have got to have 3 car parking spaces, and I'm very lucky that I can probably put one just round the side and make 4 car parking spaces. I can't remember the percentage of houses on this site that are going to that are 4-bedroom, but I presume it's going to be a few. My grandson plays out in the front garden sometimes. He helps his grandma putting plants in the garden, mow the lawn, etc. He doesn't now because he's 14, but he used to when he was 5, 6, 7, 8. If I turn my car engines on, all 4 of them, while he was there in that garden for an hour, they would be pumping exhaust fumes out. And I really don't, they're probably 8 to 10 feet away from where he would play. But again, I don't think anybody here would turn round and say that would not be harmful to a 4 or 5 year old child that's almost exhaust high probably, pumping out NO2. And if you do say it's not harmful, you're lying. What would I be told? Oh, well, don't let him play there. Let him play in the backyard, whatever. Why? Why should he? Oh, well, turn your car engines off. Why should I? I know they're idling. I'm being pedantic in a way here, because obviously there's children playing in a playground outside of this development on the A57, and there's cars going past now, and 9 out of 10 times there's probably a good half-mile traffic jam back into Glossop, for the simple reason you've got a pelican crossing outside Dinting School. You've also got traffic lights outside at the bottom of Glossop Road going to Charlesworth, which were put in supposedly to ease traffic congestion, but they've just made it worse. You've got another section of traffic lights 500 yards down the road at the bottom of New Shaw Lane. You've then got a pelican crossing, probably another 500 yards down the road near Glossop Caravans. You've then got Woolley Bridge, which is a bottleneck now anyway, and then you've got Woolley Lane going up to the Gun Inn, where there's traffic lights again. Between 7:30 in the morning and probably 9 o'clock in the morning, maybe a bit longer, there's got to be at least 5, 6, 7 standing cars outside Dinting School pumping exhaust fumes out. And that's not just for 1 minute, it's for every minute, because the traffic lights at Glossop Road stop the cars and they make them back up. You're probably going to ask me a question after, and I will put the question back to you, Mr. Barrett, but I'll ask it now actually. I'd like to know what this NO2 mean, annual mean is of obviously measuring air quality. In 2017, at Dinting School, roadside, it was 44.4%. In 2018, it was 41.3, 19, 38.9, 20, 29.3. But 2021, it went up to 32.4. On Dinting Vale, going back into Glossop, in 2018, it was 53.6. The actual safety mean is 40. It's actually 40. For 3 years, it's been above that. That was all right up to 2020. But since 2020, the cars that are going into Glossop from the new estates that have been built have probably doubled. Like I say, I'm not bothered about new houses. I think they should be built, if there's affordable housing, which there isn't in this case. So that's beside the point, because you've got over that, which is, I do understand how you've got over that, because it's not viable. And I agree with what you're saying, because that's what is in the local plan. So I do agree that you're saying it's not viable, and I accept that. But I would like to know what that means. Is that mean for every day? Or is it for a week? Is it for a month? Or can we have an example of NO2 emissions of those vehicles going past between 7 o'clock in the morning and 9 o'clock in the morning? Can that be monitored separately? Also then coming back at night, from 3 o'clock to probably 6:30, the traffic is as bad. So can that be monitored, again, just between those hours, before this development is built? Because as far as I'm concerned, I don't think that that's the case at the moment. I think from maybe, I don't know. And I'm only thinking, I don't know, because I'm not an expert, and I'm not an environmental expert. But it's like planes going over your house. From 7 o'clock in the morning to 8 o'clock at night, you might get 50. But from 9 o'clock at night to 4 o'clock in the morning, you might get 2. What I'm trying to say is the traffic going through Dinting Vale on the A57 from maybe 9, 10 o'clock at night to 5 o'clock in the morning is negligible, whereas the traffic going through Dinting Vale on the A57 outside the school at those school times is not negligible. And I would like to know if it can be done before this development is started, that we can have some kind of inquiry or monitors put in to check that pollution between those hours. If you've got a child, you're a mum, you've got a child, she's probably 4 or 5, she's just started at the primary school. But she might have another child in a buggy, you know, a kid's buggy, 6 months old, 12 months old. She's walking down the road with that child every day to take the other child to school. And she's walking back because she doesn't drive, because she's quite, you know, she doesn't like pollution. She doesn't drive, so she's walking back at 3 o'clock, 3:30, with that child in that buggy. All the exhausts are at that child's head. I've seen it going across Glossop high streets. A mum's pushed a child into the road where a car's actually been on the pit, parked up with the engine running, exhaust fumes coming out. And I thought, no, don't do that. Don't do that, because those fumes will get on your chest. And that's happening day after day after day. I walk that road probably 8 times a week. I've got a brother-in-law lives in Hadfield, sister-in-law lives in Hadfield. Both my sons live in Hadfield, and I walk down that road at different times of day. And you wouldn't tell, but I've got asthma. And there's quite a few in our area now, and it's becoming more prevalent because of fumes from cars. The North Circular Road in London, a little girl died years ago, and that was proved it was through car exhaust fumes. Asthmatics struggle with car exhaust fumes. It's simple as that. I walk down that road at least probably 8 times, maybe more than that, a week. And you can tell the difference in the air quality. If you walk home at night, I mean, all right, you might have had a few drinks as well, but that doesn't affect my smell and my taste. Coming back from my son's at night, there's no smell. There's nothing. You go down at 7:30 in the morning or 9 o'clock in the morning, you can smell the car fumes. You can taste them. So why on earth should residents and a school and 200 school children put up with those car fumes getting on their chests, probably causing problems? Well, not probably, but are causing problems. As again, I'm not a doctor, neither are you, so I can't say they will cause, and neither can you. But a doctor would sort of say, well, I think it might cause problems. It's a ridiculous scenario, an absolutely ridiculous scenario. And to say that, just let me find this because I'm not very technically savvy, but proposed Section 106 package, I think this is it, fails to achieve a policy compliant level of affordable housing and fails this. Right, this is the one I want. The A57 Dinting Vale is already designated as an air quality management area, and there is potential for the level of pollution in the area to be further increased due to increased levels of traffic, leading to concerns around the impact on health of people and in particular children in the area. Whilst it is acknowledged that the developer proposes a Section 106 contributions to air quality monitoring in the area and sustainable travel feasibility studies, that's really, it's the air quality. What is the developer going to do to monitor the air quality when the houses have been built? Because surely, if it's speculation on my part that will increase, it's obviously speculation on the developer's part, albeit he's been given information by experts that it won't increase. In fact, it might decrease because of electrical vehicles. Well, surely, if the air quality monitoring is done then, and it gets worse, the developer won't buy everybody on that development an electric vehicle, and he certainly won't have the houses pulled down. And that's all that can stop the pollution. I just find it absolutely disgraceful that a supposed developer who thinks about the people of the area and residents in that area can actually look at building these houses. I don't care where they're put. They could be put anywhere as long as it's not outside a school where the road comes down and it's the only actual egress and access from that estate. There is more I could say about pollution, but to be honest, I think I've said enough. The other point is that you were talking about gradients on this coming from the development. I live on Simon Lane. I've just been talking to somebody now about gullies. This is DCC's problem. I know it's not the developer's problem. I do realise that. But I walked from the middle of High Street West up to my house on Simley Lane, which is about 1.25 miles. And I did it just to prove a point, really, not to you, but to DCC. And I put 3 complaints into DCC about gullies being blocked and flooding problems. 32 gullies in the space of 1.5 miles are actually full of silt. I've been in touch with DCC to do the job. I've had 3 different case notes. What I'm coming to is this gradient on this hill. It's probably like walking up Snowdon. And it's like that. The water that's going to pour off that site, it pours off it now, but in a regulated way because there's soak away with the trees and the soil, and of course the small brook that goes through it. Water is going to pour down that. It's going to pour down that at some rate. If we get the rain that we've had over the last 3 months, those gullies are going to get full, whether they're silted up or not, and it will cause flooding problems. There's flooding problems there now when it rains lightly, so it's going to happen again outside the school. Those are my main objections. I don't really know how I can say it any better than that, and I don't know what questions I'm going to be asked. And obviously the expertise of these ladies and gentlemen is better than mine. But as you can see, I don't think anybody will turn around and say that exhaust fumes don't cause a health problem. That's me done.
Thank you, Mr. Hardy.
Yes.
Mr. Barrett.
Good afternoon, Councillor Hardy.
Good afternoon.
I'm going to ask, I don't know if you on your laptop.
No, if you're going to ask something out of this, I'd just rather you read it to me. And
well, I want you to look at 2 documents, and it may be easier for me to reference the...
I haven't got anything on my tablet, I'm afraid.
Well, I'll give the inspector the note first of all.
Okay.
CD 613 and CD 614.
Just bear with me 1 moment, Mr. Barrett. Councillor Hardy, is it something you feel? Are you trying to get a copy of?
No,
Are you
I'm
happy to just ask the question?
Yeah, I'm happy for the question to be asked. That's fine.
Thank you. If you look at 613, you may recall this because I think you are a member of the Development Control Committee, are you not?
No.
You're not?
No.
What I want you to look at is a decision of the Council in 613 of the 22nd April 2024, and you'll see it, top right hand corner of the first page, agenda item 10.
Agenda, yeah.
Got it?
Got that.
And it's from Head of Development Services, and if you look to paragraph 2, the recommendation is that the committee resolve to not pursue a defence in respect of reasons for refusal 2 and 4. And for your note, 2 and 4 relate to highway matters.
Yeah.
Reason for refusal 1 is the AQMA point, the air quality point, isn't it, you will recall?
Whatever you say.
Yeah. You will know from your knowledge of this application that recommendation was accepted and those 2 reasons for refusal were withdrawn. Correct?
Doesn't mean it's right.
Sorry?
It doesn't mean it's right. Whatever you say, but it doesn't mean it's right.
Okay. Doesn't mean it's right according to yourself.
It is, yeah, according to myself and probably 833 people in Simonley.
I'd like you then to look at 614, because in the body of that report, the air quality issue hadn't been fully discussed. And I'd like you to look at the report that was presented to the members of that committee. Do you see the list of members of the Development Control Committee? I'm assuming that you are not, therefore, the Councillor P. Hardy that's recorded there.
I am, but I'm not on the committee anymore.
You were on the committee then?
I was on the committee. You didn't ask me that. You asked me before if I was on the committee, and I'm not now. I was then.
Well, I'll go back to my question then. Were you a member of the committee at the time
Yes.
of the decision that's 613?
Yes.
Did you accept the recommendation and vote for it?
Can I tell you the truth? I was pushed into it. I really...
Would you like to answer my question and then qualify it if you want? Did you vote in accordance with the recommendation?
I did, yes.
Yes or no? So
Yes.
you actually were one of the members of the council that voted that reasons for refusal 2 and 4
You're right.
should go.
Yes,
Yeah.
you're right.
Right. Now, if you want to qualify that, please do so.
If
yeah,
I'd
so,
not-
sorry, Councillor Hardy.
Sorry.
Just to clarify with Mr. Barrett, yes or no answers is fine, and then the qualification comes.
Right,
so,
okay.
Yeah,
So I can qualify it now.
Yeah, you
Thank
can.
you.
You
Thank
can
you very
qualify
much.
any answer, and
Thank you.
it doesn't. Acceptance doesn't necessarily mean
Okay.
that it undermines your overall what you're saying.
Thank you very much.
But the qualification is then important. So yes.
If I'd known at the time that this was going to happen today, I certainly wouldn't have voted to accept that. And I'll say that openly now. I would not. I'd have opposed it.
What, I don't understand that.
Well, I voted yes.
There were 4 reasons for refusal. That committee report at that time, I'll come back to air quality in a moment, said, we don't think we can defend 2 and 4. And you've got a binary choice. You either accept that recommendation or you don't, and we know that you did accept it, but you may have taken the view, well, okay, we've lost on 2 and 4, but I think we've still got a strong case on 1 and 3. That may have been your thought process.
It probably was at the time.
Right, okay. I want you then to look at, it's the next document in the bundle that you have, 613. They may be, it's maybe paginated. Just, do they have those finger flags where you can sort of pull it out? Can somebody help Councillor Hardy?
Yeah, just...
Do you have a document that's headed private document pack, High Peak Borough Council, and there's a date referencing the Development Control Committee agenda for Monday the 22nd of April? This is, I think this is the update that's referred to in the earlier report.
Is this in agenda item 10 still?
No, it's the next document.
614.
614.
Page 3, 614. Am I right? That's where I'm at. Is that correct?
It's 640. I'm asking this councillor to look at 640,
Right, okay.
which is, this is the updates for that committee meeting that Councillor Hardy was there.
Right.
Page 3.
Page 3.
I don't have a pagination on mine.
Yeah, I've got a version that says page 3 as well.
My 614 is a supplemental CD14 supplemental confidential update sheet.
Correct. Yes.
That's it.
And that's this.
What I don't have is a page on it. Okay. And I can see, let's see if it's the same document, you are listed as a member of the Development Control Committee.
Correct.
This specifically deals with air quality, doesn't it?
It does.
And if you then go, agenda item 10, top right-hand side, is that page? It's the PDF page 3 for sure, references air quality and the fact that the AQMA was designated in 2019 after the adoption of the local plan. You see, that's the second line.
Yeah.
Then there's a heading, air quality assessment background.
There is.
And I'll try and summarise that, but if you think I'm unfairly summarising, say so. This application had to be subject to an air quality assessment, the scope of which had been discussed at a pre-application stage, and you can see there's a date in brackets there, February 2022. The proposed methodology, it says, was generally accepted, subject to a few comments, and was in line with the recognised best practice. The consultancy the applicant used for the assessment was a company called Royal Haskoning, who are a well-established and recognised environmental engineering consultancy. I'm interested in what you were being advised. There's then a discussion. I don't think you and I need to discuss that, but you'll see a number of bullet points over the page. Under the heading on that next page, reports assessment heading, the second paragraph reads, the initial report, that means my client's report, the initial report was not, and they underline the words, not accepted by the council, and concerns regarding the report were discussed directly with the applicant in a meeting on the 22nd November 2022. So let's just pause there. This is the Environmental Health Department of the council saying, look, competent consultancy, we've got a report from them, we're not accepting it, we've got a number of concerns. There's then 3 bullet points following on. In response to the above comments, the applicant produced a revised air quality assessment. And there's the reference to the document. This report also includes copies of the comments raised by the council in response to the initial report. Next sentence. Despite being a significant improvement on the initial air quality assessment, the report was still not accepted by the council at this juncture. Primarily, you'll see, because the County Council Highways had not yet accepted the transport assessment. And because the transport assessment generated how much vehicles would be generated, self-evidently, that would impact upon the air quality assessment. You can see that discussion goes on. Over the page, following on from the bullet points at the bottom of page 4, members could access, as I understand it from this document, the actual original documents. And then it goes on to say this. In response to the above comments, the applicant produced a revised AQ, air quality technical note, to address the issues raised. It was considered that these responses, in addition to the acceptance of traffic data used in the assessment by DCC, that's the County Council Highways, was sufficient to address our outstanding concerns regarding the assessment. Our objection on air quality grounds was thus removed and the conclusion of the AQ reports accepted. These conclusions were that the impact of road traffic emissions generated by the proposed development on existing human receptors, including within the AQMA, was predicted to be not significant. They underlined that, not significant.
I can see they've underlined it, yeah, thank you.
In accordance with guidance, I'll summarise again. And the annual mean concentration, carbon dioxide, PM2s at 2.5s and PM10s, those little particulate matters, were predicted to be below the relevant air quality objective at all locations, both without and with the proposed development. Goes on, Council's EHO accepted the report. We also noted our support for the recommended conditions by County Highways relating to electric vehicle charging, secure cycle shelter provision, and the implementation of a travel plan. These actions are all considered to be recognised forms of mitigation of impact of the development on the local air quality, though essentially the promotion, encouragement, enabling of low emission vehicles and promotion of travel alternatives to provide car use, and are all measures that are specifically outlined in our draft AQAP for the area. There's a however, which we shouldn't ignore. We also noted that despite the impact not being deemed significant, there was still an impact albeit only a slight increase. So we considered that it was appropriate that the developer should support the actions the council is wishing to undertake to improve air quality in the form of a financial contribution to help implement actions associated with the revised air quality action plan, namely the installation of real-time monitoring of carbon dioxide and particulate matters, and possibly to support a further feasibility study into local sustainable travel in the area. These requests are consistent with the following proposed actions from the Air Quality Action Plan. Now, I'm going to stop there. I've read it out at length so members of the public can hear it as well. It is clear, isn't it, that the environmental health officers of the council plainly accepted that there was no air quality justification to refuse the appeal application. That's their view.
Yeah. However, we also noted that despite the impact not being deemed significant, there was still an impact.
Sorry?
Sorry. Do you want me to turn to I'll turn to you and say it, if you like.
Your answer should be directed to the inspector who's...
No, the answer threw me.
Well, I was facing you.
No, it's fine.
Yeah. However, we also noted that despite the impact not being deemed significant, there was still an impact, albeit only a slight increase. So we considered that it was appropriate that the developer should support the actions the council is wishing to undertake to improve air quality in the form of a financial contribution to help implement actions associated with revised air quality action plan, namely the installation of real-time monitoring of NO2. Can I finish there? Because
see, my client's proposal...
I was still talking to the...
Oh, I beg your pardon.
Yes, Mr. Barrett, I'll let him finish the point.
Thank
and
you.
Then bring you in.
It says real-time monitoring of NO2. Does that mean total... This is what I was coming to before. Is that daily monitoring from midnight to midnight? Why isn't it monitored when there's more vehicles going past that? An average is dead easy. I can give you averages of everything. But an average doesn't work in this case. It definitely does not work. An average is an average of 24 hours. We're looking at 2 spots of basically 2-hour periods. If I don't want this development because of this, but if you could prove to me, if the developers could prove to me, which isn't going to happen, definitely not, if they could prove to me that the air quality between 7 o'clock in the morning and 9 o'clock in the morning and 3 o'clock in the afternoon and 5:30 in the afternoon or 6 o'clock when people are coming home from work doesn't exceed the safety limits of NO2 emissions, I wouldn't be here now. I would have accepted it right away. But you can't. You cannot do that unless you monitor it for those periods of time. And again, if you tell me I'm wrong, you're lying, because you can do that and there's nowhere near as much pollution goes through that area from 8 o'clock at night to 6 o'clock in the morning.
Well, Miss Whittle will directly address that point. It is already directly addressed in her evidence. But I'm going to come back to my question, if I may, Councillor Hart.
Of course you may.
The environmental health officers of this council were plainly not pushovers. They challenged the information that was provided and tested it. And they have come to the conclusion, following an iterative process, that this is an acceptable development, haven't they?
Obviously they have, because it's written down there.
Yeah. Now, this was also then the subject matter of the vote that took place at the same time in relation to conditions 2 and 4, wasn't it?
Correct.
And my understanding, correct me if I'm wrong, Councillor Hardy, is that the Development Control Committee also accepted that they could not credibly pursue a reason for refusal on air quality grounds. Is that correct?
It is, yes.
Yeah.
It is correct.
Yeah. So, having carefully listened, no doubt, and carefully considered the position, members decided that the reason for refusal that they initially had considered to be appropriate was no longer capable of being defended, didn't they?
Yeah.
Yeah. Did you share that view?
Not really, but I did. I just voted it with it because they shared that. shared that, and I won't say why I voted with it. I'll be honest with you, and you can ask me 25 times if you want, but I will not say why I voted for it.
But as a matter of fact,
I voted for it. I'm just saying to you that I voted for it.
I just wanted to be absolutely clear. As a matter of fact, that having heard an explanation, your response was to vote such that the council would not, at this appeal, pursue any air quality objection to the proposal. Am I right?
Obviously, you're right.
Yeah, I'm right.
Thank you, Mr. Barrett. I think we've got.
I think
that
the point's
point.
there, isn't it? Now it doesn't have to be.
I think we do
pushed
have that
anymore,
point.
yeah.
If there's the question helps me to move it on, please.
Thank you very much, Mr. Beg your pardon, Councillor Hardy.
No, Paul will do. Thank you.
Thanks for your evidence, Councillor Hardy. I don't have any specific questions to ask you, because I know that you left some questions of your own hanging in the air, and those will be helpful to me in terms of the evidence that will be presented on behalf of the appellant tomorrow on air quality. I expect that those questions that you raised will be addressed in some form. If not, I will ask a form of them.
Thank you very much.
Because they are questions that I need to understand as well.
Yeah. Okay. Thank you.
Thank you, Councillor Hardy.
So am I now? I've got a statement here from Councillor Elliot Starkey, who is the Borough Councillor for the Dinting Ward, and he's a governor at the primary school that's going to be affected directly by the pollution problem. Am I allowed to read this out now while I'm here?
You're allowed to read that statement. In terms of questions, I'm presuming because it's not your own statement, it's not something that you wish to answer questions. Well, the only thing I'll say is obviously I'll just take Mr. Starkey's point as read, and the fact that it can't be tested in the inquiry format, and I've just got that's the point that's got to be made.
Right, thank you.
So could I just ask whether you would want that statement, if it's in a suitable form, to be admitted as an inquiry document, so that to save our pens?
It may be helpful to me if there's a way of providing it as a hard copy, or would your preference just be to read it out?
I'd rather read it out, please. Like I say, I'm not technically savvy, really. If I can read it out, that would be great. If our barrister doesn't mind.
Okay. All I'll say is that I'll make a summary of it in my notes. It won't necessarily be word for word, because I can't write that fast.
I mean, the thing is, obviously, I could. I don't know. I can send it as an email later on, but I can't do that now.
No, I don't mean right now. It may be something as long as it is that same statement. It may be something that we can.
If I can take an email address, I will do that this evening when I get home.
We'll sort that out.
If you arrange that with the council, and the council can provide it first thing in the morning as part of an update.
That's fine.
Okay.
Okay, that's fine. Please find below my statement in objection to the Adderley Fields development. Obviously, thank you, Chair. This proposed development on Adderley Fields could be disastrous and should not be accepted. When you look at the proposal, this development would bring zero benefit to local people and in fact make their lives worse. My first point I want to raise is on the basis of biodiversity. No amount of money would reverse the damaging effects of this proposed development. It's a crucial area with abundance of wildlife, including deer. Last time I checked, deer don't accept cash to move to a new area. This is a beautiful place of land which offers local people a green space to admire. We all know the links between mental well-being and the outdoors. Removing this area in our community would make it harder for local people to benefit from the great outdoor spaces we have, resulting in many needing to get in a car and benefit from outdoor spaces. In addition, the air quality in this area is appalling and something I am working with my neighbours and the council to reduce. Please kindly enlighten us how 92 cars at least in this area will improve the air quality and not negatively impact our carbon footprint. In short, you are happy for existing residents to develop illnesses due to daily inhaling of fumes. I am sure the appellant will have a number of studies to try and defend the indefensible. How these are not credible due to the appellant conducting the studies and therefore can influence the findings through the process. In reality, I urge you to walk down Dinting Vale, see the black soot from car fumes on the windows of residents' houses and the local school. Children should not be expected to attend education only to develop long-term illnesses. I am sure the appellant may argue that the air quality won't decrease substantially as a result. I ask them to pull the other one. This isn't just numbers on a paper. This is people's health and well-being, and we should never put financial gain above health. Furthermore, if you review the site access, it is absolutely ludicrous. One road which comes out directly onto a main road, which often sits at a complete standstill opposite a primary school. If we think of this in practice, again, not some numbers on a sheet, how can this genuinely work? It will not. The risk to young people walking to school should be enough to reject this application. Regarding the access road, there is no provision for a sufficient footpath. How can this safely encourage sustainable travel? This is about real people and real lives and the catastrophic impact this will have on our community. We do not have the local infrastructure to handle any further homes. Our health services are already stretched to capacity. We have insufficient local dental provision and we don't have the road capacity for all these cars. I am sure if you're driving back through Glossop after this meeting, you will see exactly what I'm referring to. Wayne Holmes will dress this up with all sorts of statistics and studies, but surely the best study is a lived experience study. Many residents, only a fraction here today, genuinely fear the approval of this application. To summarise, due to this applicant's obsession to build on land, existing local residents will suffer by green space gone, air quality gone, biodiversity gone, traffic up, long-term illness up, all as a direct consequence. So finally, I urge the Planning Inspectorate to understand this application should not be approved and it would damage our local community. For anyone who sees the site can so clearly see this doesn't make sense. If this is approved, the builder and every single person who facilitated this development will have the guilt of destroying a community and irreversibly eradicating our diverse wildlife and causing problems with children's health. Thank you.
Thank you, Councillor Hardy. I was just keeping up.
Couldn't you go a bit quicker than that?
No, it's absolutely fine. I've made an accurate note of that. In the absence of questions, Mr. Barrett, I assume that your witnesses will address address those points raised in the manner that you can't pressure with. Thank you.
Thank you very much.
Councillor. Thank you for your time. Just before I invite the appellant to call their first witness, is there anyone else who wishes to speak or contribute today? Or happy for us to proceed on the basis that there's a further opportunity tomorrow? I'll take silence as a confirmation. So, Mr. Barrett, if you could, if you could call your first witness,
Mr.
please.
David Roberts, please.
Thank you very much for your time. Thank you.
Thank you, Mr. Roberts. Happy, Mr. Barrett, for you to proceed when you're ready.
Mr. Roberts, let me introduce you to the inquiry. The inquiry should have before them your highway proof of evidence, your appendices. There are a range of documents. I don't feel the need necessarily to visit all of them, but it may be necessary in answering some of the questions. You reference, for example, the TA and the technical notes that have been provided. Mr. Roberts, you are David Roberts, is that correct?
That's correct.
The Managing Director of SCP, Transport Planners and Infrastructure Designers. You are an incorporated engineer of the Engineering Council, a Fellow of the Institute of Highway Engineers, and a Fellow of the Chartered Institution of Highways and Transportation. Is that all correct?
That's correct.
You have over 40 years' experience of the highway traffic and transport aspects of all types of development proposals, and you've advised many companies and local government authorities in that capacity. You were instructed in this matter in February 2021, and you have carried out observations and investigations that led to the production of the transport assessment and the other technical notes that support the planning application, and you have a professional witness declaration at paragraph 1.5 that you confirm that the opinions that you are expressing in your evidence are your true and professional opinions and have been prepared in accordance with the CHIHT Code of Conduct.
That's all correct.
And that, just to summarise that, because people may not read that as frequently as perhaps others do, that requires you, irrespective of the party you're representing, to inform the decision maker, whether it's a judge in the county court or a planning inspector or the Secretary of State, to provide your full professional views, including your doubts or concerns. Is that correct?
That's correct, yes.
Right. I want to, following the inspector's direction, I want to take much of your evidence as read. The two principal points that you're going to be dealing with is reason for refusal 2, dealing with access, reason for refusal 4, the rat run point. Correct?
Yes.
We may also briefly touch upon accessibility and the gradient, although we have a specific engineering witness that will deal with that.
Yes, I'll deal with the principle of the gradient, and Mr. Nicholas deals with the details.
Okay. Now, if you go to PDF page 3 of your evidence, no, sorry, paragraph 3.2 on page 5, my mistake. You list, by reference to a number of bullet points, agreements that you made with the Highway Authority, base traffic flows. Is that a measurement of the traffic flows?
It is. It was for the capacity assessments on various junctions. We obtained the 2021 traffic flows through each of those.
And you tell us that was the busiest hours of the day?
It was. We generally survey 2 hours in the morning, 2 hours or 2.5 hours in the afternoon, and then find the busiest 1 hour period in the morning, the busiest 1 hour period in the afternoon. We concentrate on those busiest periods.
You tell us the second bullet point, further traffic surveys undertaken on the A57 in 22 to record vehicle speeds in the vicinity of the site, and that's to inform the visibility requirements.
It was. That's correct.
Yeah. They were speed surveys, were they not?
They are. They also record vehicle numbers as well as speeds, but it was intended for speeds in that purpose.
Bullet point 3, you look at the accident record, and specifically you're looking for personal injury accidents.
We are looking for clusters and any accidents that have similar characteristics or causes, but obviously in this case there were no clusters that were of concern to ourselves or the Highway Authority.
Right. The next point really is the accessibility point. This is by reference to facilities, services and the like in nearby centres and whether there are sustainable means to access them. You make the point in that bullet point that yes, they do, and there's public transport available, indeed a railway station available nearby.
That's correct, and it forms part of the Statement of Common Ground as well.
Yeah. Next bullet point, you tell us in the busiest hour of the day the development-related traffic movements will be the equivalent to an average of 1 vehicle every 2 minutes exiting the site in the morning peak hour and 1 vehicle every 2 minutes entering the site in the afternoon peak. Is that correct?
That's correct.
You tell us then the development traffic will have no material impact on the local highway network in terms of highway safety or highway capacity. There'll be no queues or delays at the proposed site access, and you reference then next the travel plan will be implemented as part of the development proposals to encourage future residents to minimise single occupancy journeys.
That's correct.
Right. There's another issue that I think you touch upon at 3.3, and that's a development consent order for the Mottram bypass. How will that impact the development proposal in the widest sense? What will be the consequence?
There are a couple of consequences for the local area. The principle of providing the Mottram bypass, this is a Glossop spur of the bypass, has the consequence of reducing the journey times between Glossop and the M67 and vice versa. So in 3.4 I've talked about, this is taken from the Highways England report, that there will be an 8 to 10 minutes saving in the eastbound direction from the M67 to Glossop, and a 5 to 6 minutes reduction in journey time for the westbound journey from Glossop to the M67. Just on the other consequence, obviously, there's a reduction in journey times. There are a number of vehicles that divert away from Dinting Vale at the moment using what we call less desirable routes, and by reducing the journey time there will be some traffic attracted back to the A57, so there could be an increase in vehicle movements locally as a result of the journey time savings that the people will make.
Okay. That's because people are currently diverting somewhere else to avoid the A57.
That's correct. There's various routes to get to the M67 without going through Dinting, which are quite long detours, not great roads, but that's what people do to save time.
Okay. Section 4 then, you deal with the third party concerns. You put 2 bullet points here: the position of the site access, and then there's the Adderley Place public right of way to be used as a rat run. Dealing first with the position of the site access, I note that paragraph 4.3 you explain that Wayne Homes actually acquired additional land beyond that shown in the allocation to improve the access. Is that right?
That's correct, yes.
Just explain why that was considered appropriate to do. There was an allocation.
I don't know how the frontage to Dinting Vale was arrived at during the allocation, but when we came to draw up an access, a suitable access, which has a 5.5 metre wide carriageway, which is normal standard, footways on each side, generally a 6 metre radius on each side of the junction, that didn't actually fit within the land that was shown in the allocation, so it was necessary to obtain further land. I think I also mentioned that there was an issue in that there's a driveway adjacent for number 41 Dinting Lane, and putting the access as it was shown in the local plan allocation, that driveway would have come out right on the radius effectively. So by acquiring additional land, we've been able to make sure we fit the ideal standards in for a junction, and also avoid any conflict with the existing access to number 41.
Just one question as a matter of fact: would the proposal, including the access that's to be provided here, meet DCC standards for adoption?
Yes.
In terms in visibility displays, there was a bit of an issue about this. You use Manual for Streets, which is a publicly available document, to work out the visibility displays initially. The County Council wanted speed surveys. When you did the speed surveys, if I can summarise it, the visibility display you're providing is actually greater than that required by the speed surveys.
That's correct. We went on the speed limit. It would require 43 metres visibility displays, which we've actually provided. The speed surveys showed that the design speeds were less than 30, around 28 miles an hour. So the requirements is only 2 miles an hour, but it does make a difference in standards.
Now, one of the concerns, perhaps the most important concern articulated by objectors, is the proximity of the access to the school. Will you just take us through that in terms of what issues ought to be considered in terms of your fact 411 onwards, really? What ought to be considered in proximity to the school?
Yeah, I think I've started in 411 by talking about it shouldn't be a bad idea constructing houses near to schools. One of the biggest problems you have around schools is that children are dropped off by parents using cars. So you need to encourage more people to walk to school, and by building within a walking distance of a school is a definite benefit at the starting point. I've talked about congestion around schools is not uncommon. In fact, the vast majority of schools, if not all schools, have short periods. I think it's generally assumed to be 20 minutes in the morning, 20 minutes in the afternoon, where the parents or guardians take the children to school. They suffer the consequences. They're moving in and out of trying to park up to drop children off as near to the school access as they can. They cause a lot of the problem, and they suffer a lot of the problem. So it's self-perpetuating. If you're not using the school like I do, I will adjust my journey time where I know there's a problem. So that's something you can do around schools just to avoid the worst of any conflict that happens there. I think I've talked about how far it is, whether it's, so in my paragraph 415, I've talked about that site access is 60 metres from the school's pedestrian access and 75 metres from the pedestrian crossing, which is on the east side of the school. There's no definition of what's close. Close is not 60 metres too close, is 75 metres too close. There is no definition of being close to a school. There's no policy requirements, there's no technical guidance that says you can't put a junction any distance from a school. So there's no conflict with any policy by having an access 60 metres from a pedestrian access to a school. There's parking restrictions outside the school, the normal yellow zigzag markings, so that protects the school gates. There are the white zigzag markings around the pedestrian crossing, which again helps visibility, so you can see if there's anybody waiting to cross the road at the pedestrian crossing. All in all, the highway meets a good standard for safety. There is no history of accidents outside the school, and by having this junction 60 metres from the school isn't going to change the standards, isn't going to change the safety history around the site. Everything will carry on working well.
414, just take it back one sentence if you like. The proposed junction has been demonstrated to meet all safety and capacity considerations for a junction of this type, and there's no inherent safety problem to justify any concerns.
Yes, I think that probably the conclusion.
Obviously, that was then the subject matter of the detailed examination reports that you provided. The Highway Authority, the County Council looked at that, and that was then the subject matter of reports to Planning Committee. Is that correct?
It was, yes.
The upshot, and so perhaps for your note, CD 3.1, I don't think we need to turn it up, paragraph 7, 10 and following, but in particular...
Sorry, Mr Barrett, can I just take that reference?
Yes. CD 3.1, sir, the officer's report.
Thank you.
Paragraph 7.10 of the report on the PDF page 43 of 85.
Thank you.
And in particular, sir, paragraph 7.10.4 and 7.10.7. 7.10.4, 7.10.7.
Thank you, got those. Not the intention to pull that up now.
No. Just a note for reference.
Thank you. I will return to it and read it as necessary afterwards.
The second big issue is the we can call it the rat run issue or the Adderley Place issue. To summarise it, members were told at the time of the planning application that this could be dealt with by way of condition to protect the existing access for those residents. Is that correct?
That's right. I think we looked at it as part of the normal planning application process. We were satisfied that there were various solutions. We identified one and said, effectively, this is one solution, but there are others. The council can be satisfied that there is a solution.
Okay. And so for your note, it's CD 3.1 again, paragraph 7.12.3, 7.12.3, page 46 of 85 on the PDF. Okay.
Thank you.
Well, notwithstanding that advice, members chose to refuse it. Reason for refusal 4 is based on the prospect of a rat run. Did you then devise a scheme to address that specific reason for refusal?
We did. Effectively, we said we would design the scheme in detail after a planning permission is granted, but as a result of the council's decision, we obviously brought it forward and started discussions with the county council and High Peak. The public rights of way officer was involved to ensure that the county council was satisfied that we didn't do anything that would prejudice the continued use of the Adderley Place as a public right of way. If you, I can talk through the scheme, just the very basic.
I think I was going to invite you to go to Appendix 1 of your appendices, and it's the first item, is it not?
It is. So,
Yeah.
yeah, Appendix 1 is the scheme drawings.
There was some mention earlier today that would the bollards have to be removed if people were negotiating this. Would you just explain how this would work in practice?
Yes, the main purpose of this is to allow vehicles that are travelling in a straight line across Adderley Place, effectively the existing vehicles that don't turn off at all, they will be allowed to continue unrestricted. The purpose of this scheme is to stop the ability for traffic to turn into Adderley Place. There are bollards shown on Adderley Place to restrict the width of it, and there are traffic islands in the proposed estate road which stop vehicles trying to effectively swing wide to get a better angle in. The subsequent drawings in Appendix 1 include the vehicle swept paths. So we've got computer software which tests out the proposed arrangement and demonstrates that a car cannot turn from the residential estate road into Adderley Place due to the width restrictions that are proposed there. In addition to the width restrictions, it's just reinforced with road signs as well.
And is that now agreed with the Highways Authority and the council, for that matter?
It is. It's agreed. I think there's still a condition, because what we don't want to say is that this is the final scheme. I think the condition talks about a scheme based around the principles shown in Appendix 1. So I think it's just to show that the bollard can move by 100 millimetres if we want it to. It's not a final construction drawing. That's all.
Then at 4.21 of your evidence, if you go back to that, if you would please, Mr. Roberts, under a heading Other Highway Matters Raised, members of the public, objectors to the scheme, referenced two items that you discuss here: the gradient of the site access and its compatibility with accessibility by sustainable modes of travel. There was some discussion not very long ago about British Standard 8300 and whether that has been addressed in guidance documents that you work with.
That's right, and I've sent Mr. Bennett, he's probably not checked his emails yet, but I've forwarded. There's a document produced by the Department for Transport called Inclusive Mobility, which references BS 8300 in its introduction, saying it takes it into account amongst other things. So it's specifically, the document Inclusive Mobility is specifically about development design in a wider sense. I think BS 8300 is designed, there's reference to it being purposely for architects to design level entrances and things like that.
Okay.
So inclusive mobility goes further.
It goes further. Clue may be in the name. High Peak Borough Council, in terms of the well, first of all, what are the standards in the document you've just referred to?
There are various standards in there. I mean, it talks about ideal gradients being 1 in 60, for example, which it regards as flat. So 1 in 60, you'd need a gradient for drainage purposes, effectively. Mm-hmm. So it talks about 1 in 60 being flat. It talks about gradients of up to 1 in 20 being classed as slopes. And then it goes on to talk about 1 in 12 being acceptable in certain circumstances and lengths. And then it splits into talking about pedestrians, about vehicles. Certainly in our discussions with Derbyshire, just moving beyond inclusive mobility, but using the principles of it, the Highway Authority were happy that 1 in 10 is commonplace in Derbyshire in the High Peak, and they didn't have a problem in recommending approval for a 1 in 10 gradient on the access road. I don't want to steal Mr. Nicholas's thunder, but we did look at options for the pedestrian route. We could zigzag the pedestrian route more along the alignment of the access road, but having discussed with the officers, the public rights of way officers, the highway officers at Derbyshire, it was agreed that whilst most people can use the footway that follows the access road, for those that couldn't, there is an alternative in the use of Adderley Place itself. So from a pedestrian accessibility point of view, the council was satisfied that the site can be reasonably accessed.
Okay, one further point really is, if one looked around Glossop, this part of the world, do you come across residential streets, residential areas with 1 in 10 gradients as existing?
You do. There are several roads. Effectively anything off Dinting Vale, I think it's in the name, Valley. So as soon as you deviate from the A57, you're generally into gradients. Similarly Lane is steeper than 1 in 20. I think it's 8%. I think Glossop Road, which is on the west side of the development, again steeper than 1 in 20, 1 in 12. There's the crossroads in the centre of Glossop. You've got Norfolk Road, which serves the railway station, and there's Victoria, I think it's Victoria Drive, that goes in the opposite direction. Again, they're all steep roads, so it's not, you don't live in Glossop or travel through Glossop and meet flat roads.
The second bullet point under that heading was site access design requiring a mini roundabout or a ghost island. We heard something of this earlier, that you'd actually need a right turning lane into the site. Can you provide your comments on whether a mini roundabout or some sort of ghost island arrangement is required?
Yeah, the design of the access is based around safety and capacity. So the most simplistic form of junction is what you call a priority T-junction with a give way. That's where that's as the site access is designed. So we undertook safety considerations in terms of the vehicle speeds to determine the visibility required. That demonstrated to us that visibility was safe, so from a safety point of view it works. We undertook capacity assessments. There is industry standard software to plug in development traffic flows, existing traffic flows, and the software, which has been around as long as I have, tells you whether there will be problems at a junction. In this case, the queues were 0.1 of a vehicle, so it's not even a one vehicle queue to think about. And if you turn up there, you're likely to be the only car, because I think we talked about earlier, in the busiest hour of the day, we're looking at one vehicle every 2 minutes emerging from the site access, or one vehicle every 2 minutes in the PM peak hour turning into the site access. So it gives you a flavour of the chances of being in a queue are very remote. So the capacity software demonstrated that there is no problem with a simple T-junction as we've designed. I did see the comments. I don't think there was a name put to the report that the local residents commissioned. I think, did I hear it was 2014? But there was talk about a mini roundabout, for example, which you shouldn't use as a new design feature for a new junction. It's probably in the wrong place if you need a mini roundabout. And as well, if the side road flows are very low, traffic on the main road gets used to not stopping at a mini roundabout. They will travel through it pretty quickly. Well, say quickly, relatively quicker than you'd want them to. So a mini roundabout can be dangerous in the wrong place if the flows are not well balanced. The other option discussed was whether the junction should have, it's a Ghost Island right turn lane, we refer to it, or I refer to it as, which effectively, if you're waiting for a while for a gap in the traffic, you can wait in a centre lane so that traffic on either side of you can continue flowing. Again, the capacity assessment showed that there would be no queues or delays of any note to turn right into the site. So again, a dedicated right turning lane isn't required.
Ms Roberts, is there anything else that you would wish to add to your evidence?
No, I'm just looking to see if there's anything that the councillors raised that I can help with, but I think we've probably covered most of that.
Okay.
Thank you.
Thank you, Mr Roberts.
Thank you, Mr Roberts. We've got a little time before I'd like to take a break. We've not got enough time for my questions, I don't think, and I'll save those until after the break. But if are there any comments from interested parties, Mr Bennett? You happy to take it?
I won't stay for very long, but I'm just trying to respond to a couple of the comments that you've made. Firstly, you mentioned the measures to mitigate the possibility of using the Adderley Place Road as a rat run. Would it be possible for a vehicle to approach those bollards and then do what nobody should do but could do, and stop and reverse to a position where they could actually access and go through those bollards and down Adderley Place?
I think I know what you mean, but
well,
you can't.
The sweep, if you like, and to actually approach and then stop and reverse back to reposition and then go through the bollards?
No, almost like a three-point turn. No, it wouldn't be possible to the gap between the bollard and the traffic island in the estate road isn't sufficient for even a car to turn left or right through that gap.
So you're basically, categorically saying that nobody who lives on that estate in one of the new houses will be able to access the road leading onto Simonley Lane with the measures that you are proposing? You're saying that cannot happen.
Yes, we've taken every step we can, and we've worked with the Public Rights of Way officer, as I said, and the lady in the Public Rights of Way is also happy that we have done as much as we can with this scheme to...
I asked you specifically if it would be impossible for any car that actually comes from a house on the estate
I would say...
to access Adderley Place and to leave onto Symmetry Lane.
Yeah,
that would not be possible.
From our assessment, it's not possible. Until I'm proved wrong, it's not possible.
Thank you. And secondly, I haven't had a chance to have a close look at the document you sent me on the email, but I have had a quick look. It talks about gradients, as you say, and desirable gradients. The point I was trying to make was that from the detail I've seen just this morning of the proposed pedestrian access from the A57, it shows gradients of something like 1 in 20 as a maximum, really. But there are a couple of points where the gradient seems to either it's a camber of something like 1 in 6 or 1 in 5, or it's a section where the gradient increases to that level. And there are no, as far as I can see, there are no indications of any points where someone who is in a wheelchair can rest on a level surface. And the document I referred to, the PSA 300, actually makes the point of having maximum travel distances without being able to rest on a horizontal surface, because otherwise in a wheelchair, if you're not on a horizontal surface, a level surface, you're having to strain to stop moving either back or forwards or on a camber. So I didn't see any references in your proposal to flat surfaces where a wheelchair user might be able to rest.
There isn't, as far as I'm aware, and Mr. Nicholas will confirm this later, but the maximum gradient is 1 in 10 on the estate road where there is no development, so leading up from the A57 to the development area. The maximum, as far as I'm aware, is 1 in 10. We obviously looked at accessibility. I know you don't agree with using the cobbles on Adderley Place, but we agreed with the council that the vast majority of people can use the gradient that we've included in the development. For those that can't, Adderley Place is available for them as an alternative.
So somebody, sorry through you, Chair, somebody actually gets off a bus on Dinting Road at the bottom of that estate, and they couldn't get up the proposed pedestrian route that you're suggesting because of the gradient. They would have to go all the way back to the junction with Symmetry Lane, try to get up Symmetry Lane, which actually at that point is probably greater than 1 in 10, 1 in 12, and then try and get up onto Adderley Place and get back to the new estate. I think that's not a feasible option.
There's a couple of points there. I don't think you would go to Dinting, the bus stop near the access on Dinting Lane before you realise how steep the gradient is. You probably make that judgment that you would go via Adderley Place. The point you've raised about Adderley Place, I covered. Is exact. I completely agree. You can't live in Glossop and not meet a gradient. Similarly Lane, is that steep. Similarly, that's a Glossop Road is pretty steep going up the hill from the A57, as are getting to the railway station. That is just a fact of High Peak and Glossop. So you could say we could build a 1 in 60 level development, but to get to it, there'll be a 1 in 10 slope somewhere, and the route you've just described, Similarly Lane, is that example.
Well, finally, Chair, just to make the point here that surely within any proposal for development, we shouldn't be referring to existing poor conditions as a benchmark to replicate when we're providing new developments. because then we just perpetuate an issue. We have to be able to improve the situation in order for those developments to be worthwhile. So to cite examples elsewhere in Glossop where that isn't the case, I don't think is helpful in deciding on the merits of this particular application. Thank you.
I think shouldn't really be a comment. It should be a question to me. But I will. If I
see,
could
see if you can find a way to answer it in the way that you desire to do so to provide a response. Thank you.
I mean, in theory, can't disagree. You should be looking to improve things, but it's just a fact of life. It's not a developer's responsibility to solve pre-existing problems. In that case, we're talking about the gradient of Simmonley Lane. I could point to the capacity of the A57 Glossop Road junction as an example. All the developer has to do is make sure it's no worse after the development than it is with the development. They're not expected to solve pre-existing problems. Just not an ideal world. Sorry.
Any further questions for Mr. Roberts before we take a break? Right. Well, time is it's 3:28, just approaching 3:29. So we'll adjourn until around about 3:45, and then if it's okay, Mr. Roberts, I'll then ask my questions.
Yeah.
Thank you. So inquiry adjourned 3:29. Resume 3:45.
Yeah.
Thank you.
Dave, under the new rules, you can't discuss. What core document is that? 2.86.
Okay, it's 3:45. If everyone can take the seats, we'll resume in a moment. Okay, the inquiry's now resumed. Just before we get into my questions of Mr. Roberts, just update, housekeeping after the break. The
yes,
note.
sir. We've got the
Okay.
note.
ID 7. Thank you.
And just to let everybody know what it is, it says, with reference to the 5-year housing land supply statement, and the core document reference is given, 6.3, and having regard to your questions about the effect of the 2023 update to the NPPF, the parties agree that removing the 5% buffer would result in the supply position being 6.7 years. That's up from the 6.4 years in the Statement of Common Ground, obviously, sir. But then, importantly, the parties agree that this change in the position is not material for the purposes of this appeal.
Thank you. Okay, Mr. Roberts, are you happy to take my questions now?
Yes, thank you.
Okay, firstly, starting on the Transport Assessment Survey date. So the Transport Assessment, so that's core document, I'll just get my laptop up just in case I need it, if there's any issues. Core document 1.16 indicates that traffic flow data surveys were undertaken on Tuesday the 30th of November 2021 between the hours of 7:30 a.m. and 9:30 a.m. and 4:30 and 6:30 p.m. at the A57 Dinting Vale, A626 Glossop Road Signal Controlled Junction, and the A57 Dinting Vale Simonley Lane, A57 High Street West Primrose Lane double mini roundabout, in order to establish the existing traffic flow demand on the local highway network. And this was agreed in advance with Derbyshire County Council as appropriate. Are you satisfied that, given the passage of time since those surveys, that they remain typical and representative of existing local highway conditions?
Yes, we've got no reason to doubt that they're still of the same order. You'll never get 2 days with the same flows, but there's been no significant change in the area to justify any change to those flows. We did a further survey in 2022, and that didn't show anything significantly different.
Thank you. And then on that point on the 2022, your proof does go on to refer to that further traffic survey undertaken on the A57 to record vehicle speeds in the vicinity of the site and to inform the visibility requirements at the site access. For certainty, are you referring to the 7-day automatic traffic count undertaken between Monday the 12th of December and Sunday the 18th of December 2022 as documented in core document 2.11?
If just check on that one. It was certainly reported in the technical note, yes.
Thank you. And in that respect, was there a specific reason why those additional surveys were undertaken separately and not at the same time as those original surveys in November 2021?
Yes, sorry. So you've listed that in 2021 we did turning counts at specific junctions, and it didn't include speed survey data because there's a speed camera outside of the site which we deemed would control vehicle speeds. So it was only in 2022 that we sought to demonstrate that the speed camera was doing its job.
And that was as part of a detailed look at the visibility requirements, presumably to do with the acquisition of the land as well, to understand how to overcome those constraints, or my assumption wrong?
Yeah, sorry, the land was acquired before then. It was a question from the Highway Authority, or a point that we shouldn't rely on the speed camera to determine vehicle speeds, and that they wanted an actual survey to determine the visibility requirements.
Thank you. And then just moving on to road safety record. So your proof of evidence refers to the fact that there's been no recorded accidents in the most recent 5-year period in the vicinity of the site access or the school on the north side of the A57. Is that specific evidence before me, or is it an interpretation of the road safety record set out in document 211 dated the 3rd of April 2023 and it's Appendix B, which does include some recorded accidents in the wider area? So there are some that are outside of a most recent 5-year period, but there are a couple of notable examples, and it may be a point of interpretation, but there was one for March 2021 at the A57 Dinting Vale A626 Glossop Road junction, and 2 accidents in 2020 and 2021 at the A57 Dinting Vale and Dinting Lane junction. I did draw that out of the evidence, so I was just wondering. It was just understanding how you reach that view when there is underlying evidence there of accidents, and where the interpretation point comes in on that.
Yeah, in the proof I was specifically referring to within a reasonable vicinity of the site access and the school, because the road safety issue that we were dealing with was specifically to do with the site access and its proximity to the school.
Okay, so
when I say there was no accidents, I was talking about really within 100 metres of the site access and 100 metres of the school.
So 100 metres of the site access on that section of the A57. It was just a point of interpretation, you see, because I read the data as well, and then it's where that line's drawn on it, and it wasn't exactly clear the point that you made in that. But thank you for the clarification. The broader conclusions in core document 211 do say about the number of accidents at each junctions in any case do not represent a recurring highway safety trend in terms of existing highway conditions. In that respect, notwithstanding the evidence to be heard from Mr. Nicholas on civil engineering and access tomorrow, I would welcome your views on how you consider that the proposal is sought to ensure that the proposal would not increase the risk of accidents in that particular location.
Okay, it's a combination of geometry and visibility that we need to assess with a new junction. I ran through that a little earlier, but I don't mind recapping on visibility is the main consideration for safety. If capacity is, how should we describe, tight, then you may determine that people take more chances, which could impact on safety. But again, on this occasion, there is no capacity concern at the proposed site access.
So taking on board some of the comments that residents have said, and notwithstanding trip generation, etc., there are evident bouts of congestion. I've experienced one myself in a familiarisation visit. So there is slow moving traffic on occasion passing the site. Is it your view that because it's relatively slow moving traffic, there will be opportunities even in those cases, and when it's not, there'll be gaps in traffic to allow people particularly to turn right out of that site access, and also to turn right into it from the A57?
Most definitely, because as you say, standing traffic, someone may be parked across the junction inconsiderately, we could say. It may be that there's a keep clear sign in markings may be introduced. That detail is to be resolved as part of the Section 278 agreement for detailed design. But standing traffic generally isn't a safety issue, because someone will let you join the A57, particularly for turning right in. That is a very safe manoeuvre if someone lets you in. I think something. Sorry, I'll let you catch up on your notes. But
no, that's fine. I've got. I was just making an accurate of that. So yes,
I think something we perhaps didn't cover earlier, and again, not wishing to steal Mr. Nicholas's thunder, but there is a platform on the site access, so it's not a 1 in 10 gradient meeting the A57, for example. I think Mr. Nicholas talks about a 1 in 30 platform at the giveaway line, so traffic won't, if your foot slips off the brake, you're not going to jump out into the junction, for example. There is a safe platform there.
And has that been designed at a distance that fits with the evidence in terms of potential queuing times? And I know what you've said about limited queuing times in those locations.
Yes, on the site exit, there's no queue at any time as far as the capacity assessment shows. So you certainly get 1 or 2 vehicles effectively standing on what I'd say is a flat platform whilst waiting to join the A57.
And in terms of the configuration, there's enough forward visibility on the actual access itself to account for the gradients and the stopping distance for anyone that's maybe waiting on that platform.
Yes, yeah. There's no retaining walls or sharp banks that would prevent forward visibility along that route. Again, it's not a high-speed access road with the alignment. There are a couple of turns in there which will restrain vehicle speeds. I think we'd expect 20 miles an hour on that road, on the estate road.
Thank you. And then moving on to trip generation. So your proof of evidence refers to the estimated trip generation of an average of 1 vehicle every 2 minutes exiting the site in the AM peak hour, and 1 vehicle every 2 minutes entering the site in the PM peak hour. The entering traffic in the AM peak hour and the exiting traffic in the PM peak hour will be around, in the evidence says, around 1 vehicle every 5 minutes, so a lower rate,
yes,
effectively. For certainty, is this taken from tables 7.1 and 7.2 of the transport assessment, so that's core document 278, as based on multimodal tricks, and that was on the basis of, was that 100 dwellings rather than the proposal itself?
You're taking the words out of my mouth. It is those tables you've referred to, and it was based on 100 dwellings at that time, so marginal less, nothing that we haven't redone the assessment for 92 dwellings because the 101 worked fine.
Yes, that was basically the question that I was asking. That my interpretation is that 92 is less than 100, so yeah, in theory the 100 is reflective of what you consider a cautious approach, rather to what may be what you consider may be the real term impacts in that location.
Yeah, and I think describing it as around 1 vehicle every 2 minutes overcomes that precision of saying there are 34 vehicles exiting the site or 31 vehicles arriving at the site in the evening.
Yes,
so it's
because
just
it's
that
a rounded
approximation. So
a rounded.
yeah.
Okay, just a little follow-up. The transport assessment in referring to the TRICS good practice guidance refers to the uncertainty of travel patterns following the COVID-19 pandemic and implies that it was not possible at the time to accurately predict future traffic patterns, but it was reasonable to assume that there would be a reduction in future commuters on the network. We are now a couple of years on from that, from the survey dates, and in my experience, and you may want to contradict my experience, but it would appear to me that there has been a degree of recovery of traffic levels towards pre-pandemic levels. It may not be the same, and you may be able to provide me with a particular view on that position. But in that context, could you explain the extent to which you consider the estimated trip generation provided by TRICS when taken with the travel plan, so that's core document 2.36, would support your conclusion that there would be no material impact on the local highway network and no queues or delays at the site access? So it's going back a little bit to your point where you said you don't consider it significant, just to kind of explain, has there been a change from that kind of assumption in your professional understanding? And even if there is there something in the travel plan to give me comfort, did I need it, that it's offsetting in effect, effectively?
Yeah. So in terms of trip rates, we're generally finding, even the TRICS assessments that we're doing this week, the trip rate assessments, trip rate per dwelling, are coming out at roughly these same levels today. Just going back on a comment on have vehicle movements returned to pre-pandemic levels, we have these discussions quite regularly. I think the general feeling is that traffic levels have, and even though more people are working remotely, the reason why traffic is around the same as it was is because public transport use has dropped since the pandemic. That seems, I've got no evidence for that. It's just a general feeling that public transport is recording lower patronage.
Yes, and in the same way that my experience was also anecdotal, I accept that unless there's a defined study that shows that definitively and possibly localised to the Glossop area, it may be difficult to. It may be difficult to define, but I think that does accord with my general feel. And in that sense, given the assumptions were in the transport assessment, we're about maybe not reaching that particular point. Are you still satisfied that there's enough flexibility, or with the travel plan that there's enough there to offset that passenger time and any potential change?
Yes, I think we're happy that the trip rates are still relevant. As you say, the travel plan adds an element of robustness because the trip generation exercise didn't pick out specifically sites that had a travel plan. So this is in the TA 7.2. We generally list out the criteria that we've used in the assessment.
Just bear with me 1 second as well.
No problem.
I'll try and get it up. Sorry, was it the travel plan or the transport assessment?
It's the transport assessment 7.2. It's just where we were talking about trip rates, really.
Page 28. PDF.
I'll make a note and I'll refer back to it.
It's just a list of criteria that we use to generate the trip rate, and there is an option just to pick sites with travel plans. and you would expect a lower trip rate from a site with a travel plan, but we didn't factor that into this assessment. So it comes back to the travel plan should be an element that will restrain trip rates in this instance.
Yes, so and it's a cautious approach overall then?
Yes.
Okay. Okay, moving on to the Bottram bypass, the development consent order. Your proof of evidence refers to the development consent order and provides an overview that whilst there may be journey time savings beyond Glossop, and some existing roads in the area will see benefits in the reduction of queues and delays, the bypass scheme is predicted to increase traffic on some roads in the study area, and we've already heard that, as traffic diverts from other less suitable routes. You go on to find that the effect of the scheme in the context of the appeal proposal, that the relief at the junction of the A57 A628 and the Mottram Crossroads, so that's the A57 A6174, arising from the bypass will more than offset the increase in traffic. For certainty and to assist my understanding, whilst you've indicated that the Highways England Transport Assessment, so that's core document 6.20, does not include specific junction capacity assessments close by, it would appear that a degree of sensitivity testing has been undertaken alternatively in core document 211.
Yes, that's one of our technical notes where, again, I think there was a later request from the Highway Authority to assess the impact of the Glossop Link Road spur.
And that's where them conclusions come from then, effectively?
Yes, there was a capacity assessment in that core document you referred to look at the changes arising from the Mottram Bypass Link Road and with the development added. So there was, at two junctions, there was a reduction in capacity because of the Glossop spur, but the development traffic had no material impact on top of that.
No material impact? Yep.
No, yeah, that's right.
Thank you. So just following up in terms of the effects on local highway conditions, can you confirm whether the overall findings of the transport assessment and associated evidence take account of the full cumulative effect when taken with other committed developments? So obviously it's a certain point in time where it's a cut-off when it's published.
Yeah.
But obviously there were a number of committed developments in place, and the extent to which that it takes those into account as part of the overall findings relative to the trip generation associated to the proposal.
Yes, we just took committed developments into account at the time of the TA. I can't say, I haven't looked to see whether the commitments have been completed. Should I say that any site that had permission that wasn't implemented, I'm not sure if there has been any movement on those.
Yes, but you're happy they were all taken into account?
Yes. In part, that's the increase from committed developments is in trip rate, so there's an element of growth in the base traffic that will include
yes,
other increases in traffic.
And there's nothing you're aware of significantly in the local area in terms of permissions granted or other developments that have come forward since the transport assessment that may influence the positions?
No, not that will make again another material difference on the results. I think the percentage impacts of most developments are relatively low compared to existing traffic.
Thank you. Now on to position of the site access. Your proof indicates that it's been necessary to include land beyond the broad location of the access identified in the allocation to provide a safe arrangement with a standard 2.4 by 43 metre visibility display at the access point, which you did refer to in your evidence. It's my understanding from your evidence that geometry and visibility at the junction has been informed by standards used by Derbyshire County Council and manual for streets, corresponding with the streets surveys undertaken. In that respect, I note that Mr Nicholas' evidence will address the access and civil engineering involved in more detail. Nonetheless, I would welcome your specific views on the suitability of the proposed junction onto the A57 for the necessary manoeuvres. So I'm thinking about the practical manoeuvres in circumstances where you've got we've already talked about standing traffic, but where you've got parking on potentially unrestricted parking on either side of the access, the kind of manoeuvres that would require people who are undertaking through journeys past the site. Are there any evidence that there's any influence that may change, make it more difficult to turn into the site and turn out of the site?
No, there's nothing extraordinary. It's probably safe to say that no two situations are ever the same, but design standards are standards that we apply to situations like this. So that a junction there that we were showing as a site access would look exactly the same for a site if it was a mile away, for example. You use exactly the same standards that are proven to provide the adequate geometry and safety that you need. In terms of there is a bus stop.
I'm nodding my head in a little bit, but in terms of the qualification that I'm looking for on that you say it looked the same, but assuming the evidence base behind it was the same, I presume
yes.
That was my head.
Yeah.
My head kind of running through the logic of that, just to try and fill in the gap a little bit.
Yes, so there is limited scope for manoeuvre, if there's a pun, on design standards for residential developments. In this case, I mentioned earlier about accommodating a 6 metre radius on the entrance, for example. That is a standard that's accepted by most authorities. On a more minor road, you may have a tighter radius, a 4 metre radius, for example, which may cause more delay on the main road because you have to negotiate it slower. If it was an industrial estate road, for example, you'd have a 15 metre radius to accommodate a trailer. Yeah. So a 6 metre radius is a reasonable compromise between safety, because you have to take it more slowly, but not to a degree whereby the back end of a car's lingering on the A57 for longer than it needs to, if you can understand my analogy there.
Yeah. So my understanding is 4 metre radius would require you to approach it incredibly slowly, because it's a much tighter turn in there. So the 6 metre radius you consider as a compromise. So vehicles still will need to slow to gain access, particularly for a left hand or a right hand turn into it, but not to an extent that you think that it will cause an obstruction for traffic travelling at a reasonable separation distance that you typically expect on the A57.
Yeah, it's like many things. I mean, the differences are probably very small. So it may be at a 6 metre radius, you would take it at 10 miles an hour. If it was a 4 metre radius, you might take it at 8 miles an hour. They're very subtle differences, but every little helps, as they say.
Yeah, so the difference in speed in that extent is that it's less likely to cause vehicles behind have to slow and stop. So the separation, as odd as it might sound, actually being able to go through a turn at a faster speed is less likely to require vehicles behind to actually have to suddenly stop or
less
or
likelihood
brake.
of a shunt or something like that.
Yes. Yeah, it's trying to. I feel like I understand, but it's trying to understand the mechanics of that in the real world, really. Thank you. And then moving on to dismissal of, well, your dismissal of the need for a mini roundabout on Ghost Island. Again, you've covered this in quite a bit of detail in your evidence. You do reject the option at the site access of the need for that right turning lane on the basis of the capacity analysis indicating no queues or delays arising from a simple priority junction. Just in terms of the on-street parking situation, and I know we discussed about the Facebook post, etc. But my familiarisation around the site, I did notice that there were some in the unrestricted area on both sides of the road. There has been some on-street parking. It may not be to the extent that local residents, a particular local resident, might be trying to encourage during my visit, but nonetheless, I have noticed it there already.
Yes.
Just in terms of that kind of manoeuvre where vehicles are trying to navigate in both directions, is the forward visibility sufficient that it wouldn't come as a surprise where people are encountering those parked cars, and if someone's trying to turn right at the same time, there's no potential for confusion?
No,
at that moment?
the road it's a relatively straight there. You've probably got 400 metres or so of straight road, so visibility is good along that road. And in my experience, the on-street parking doesn't prevent the two-way flow of vehicles. You don't have to wait for an oncoming vehicle to pass a parked car before you can continue. There are quite a few. There's a combination of events that lead to parking restrictions. So the bus stops have got bus bays, so there's no parking there. There's the school zigzags, the yellow markings for the school, which prevent parking outside the school. And then beyond that, you've got the zigzags for the Pelican crossing, which again restrict traffic.
Yes, and the Pelican crossing is the one that we referred to. That's after the school.
Yes.
Is it in front of the church? Pretty much in front of the church.
Yes, it is. Yeah.
I did note it when I was in that area.
Yeah. So there is. I mean, obviously, we're going to the west of the site access. There are terrace properties.
Yes.
I referred to number 41 because it's got a driveway. Beyond that, there are some terrace properties which I don't think have off-street parking, so they park there.
Yeah, there seem to be some gaps between the terraces. I think one of them is the actual end of the footpath that runs through the site a little bit further on. But I think I noticed there were a couple of where there may be. I can only presume there may be vehicles parked to the rear using the side of the end of the terrace. But that's anecdotal. I can't say that I saw that specifically.
Yeah, it's because the A57. It's not a narrow carriageway, so it does accommodate that on-street parking without. That doesn't cause any delays. Let's put it that way. When you see standing traffic, it's because of the traffic signals at Glossop Road rather than any impacts from on-street parking.
Yeah, so it's junctions and signals elsewhere.
Yes.
Okay, moving on to Adderley Place, the vehicle restriction. Again, I know you've covered that in the evidence, and you've also provided responses that I've already taken into account to Mr. Bennett's questions before the break. Just to assist my understanding and complement the submitted plans as submitted in Appendix 1 of your proof, can you briefly explain how the proposed vehicle restrictions will constrain or discourage vehicles from turning on to the eastern section of Adderley Place whilst maintaining the existing levels of access for residents along Adderley Place to and from Simonley Lane, and whether there are alternative options which have already been discounted? So I think the way I was looking at the plan was, firstly, would there be a reason for someone to want to travel down Adderley Lane as an alternative rather than down the access road or vice versa. But also whether there is any form of manoeuvre that could, and you may have answered it in your response to Mr. Bennett previously, but I was just trying to understand that, and also understand the points that have been raised about emergency vehicles. So particularly emergency vehicles going up Adderley Lane, in terms of talking about constraining widths with bollards, etc. Do the swept path analysis include?
We have done. I'm just checking the appendices. We ensured, yes. So the swept path diagram.
Yeah.
Top. Is it second page of the appendix? Let me just have a look. And there's four swept paths, but the top right hand, it says large refuse vehicle, which is just travelling. If you're on the same diagram as me, it just shows a refuse vehicle travelling from Simondley Lane along Adderley Place and just continuing straight across as they do today.
Okay.
So that was a principal consideration to ensure that we're not restricting any movement along Adderley Place that occurs today.
And how does that compare to like a fire appliances?
The refuse vehicle is the largest vehicle that you would expect in a residential area. So they're about, that one, sorry, mine's A4, they're usually about 11.4 metres long. But whatever length they are
Yeah.
still, that's the vehicle to design for in a residential area.
So it, in your view, it can be applied equivalence to a fire appliance.
Yes,
in terms of width and depth of vehicle.
Yes, the fire appliance is generally smaller than the refuse vehicle.
Okay, and then just in terms of alternative options, were there any alternative options that you considered?
I think this really is an iteration of discussions we had with the County Council to get this as near as complete as we could. Because, for example, it was a matter of the Adderley Place residents wanted to protect their rights that they already have, which is fine. We had to consider whether a delivery vehicle might want to turn left towards the houses, so on the western section of Adderley Place. So it was discussions with the council that the bollards on the western side of the junction might not be required, so that allows the post deliveries, for example. Whilst we said we don't want traffic to turn from the estate road into Adderley Place to get out to Simondley Lane, a post office van might want to turn it'll go into the estate, and on its way out it can turn into the houses on Adderley Place.
Yes, you preempted my next question. That was my question. When I looked at the plan, it looked like that manoeuvre was possible. That manoeuvre was potentially possible. But the broader question was, it would, who would be incentivised to use that as a matter of convenience? And I think you've answered the question that I had, because I think I would have concerns if that manoeuvre was possible, particularly down the eastern pathway, because it may be more convenient for someone to leave in that direction. But my understanding, and having walked the route along the western section, is that it becomes a private drive effectively that terminates towards the end before it becomes a public footpath again, a single track, rather steep and not particularly navigable if you're not in don't have the greatest footwear. I'm talking from experience, so.
Yeah, I've been there too. But yes, there's no, unless you're visiting those existing properties in Adderley Place, there's no reason for a vehicle to go down there because it is a cul-de-sac for vehicles.
Yes, so you'd only really see it as a matter of convenience. So, for example, either someone pulling onto the estate to deliver to those properties to then go onto the wider estate, or vice versa, coming from the upper portion of the estate to go into Adderley Place to address that.
Yeah. So there's the removal of the bollards on the western section allow the cul-de-sac section to be used a bit more freely than. We've done a total prevention of anyone turning into the eastern section of Adderley Place.
Yes, and for my understanding, those vehicle movements would still be taking place because, in theory, those vehicles would still be alternatively travelling round to go up Simmonley Lane along Adderley Place. So the volume of traffic, would it be materially different if they were to undertake that manoeuvre?
Sorry,
sorry,
got a bit lost.
Sorry, would it be materially different for if vehicles were turning in from the development site along the western pathway for deliveries, etc., as part of within the scheme, as opposed to alternatively, if that was restricted, having to go down the access onto the A57 to go round and back? And my understanding is that those deliveries would need to take place regardless, in theory, whether it's post office or common shopping delivery services that we probably can all name.
Yeah. So they wouldn't be able to, a delivery vehicle wouldn't be able to go down from Simmonley Lane along Adderley Place and then reach the new development.
No, it'd be the other way around, wouldn't it?
Yes, so the only way a vehicle can get out of Adderley Place onto Simmonley Lane is to come from the existing properties. So a vehicle can travel straight through the restriction. It can't turn into it.
So the restriction is to stop it turning onto the new development, which is necessary because then that stops vehicles turning onto that route. But what I was driving at was there isn't really a material difference if you, for example, if you were in the development and you were higher up and towards the higher number plots, coming southwards towards the Adderley Place junction, and you decided to turn left as a delivery vehicle there, your alternative, if that was restricted, would be to go out of the site access, to go to Simmonley Lane, to come up Adderley Place to make that same journey. So it's reducing the journey time as opposed to having any material difference in terms of the number of vehicles potentially using that route. Yes,
and I think there's a potential reduction in the traffic using Adderley Place because a vehicle from the existing houses has the option to either go, as they do now, all the way straight through to Simmonley Lane, or without the bollards, they can turn left and go out to use the estate road. So the residents of Adderley Place have got a choice.
Yes, so the absence of restrictions on that western route, it allows direct access for delivery vehicles. Well, basically any vehicle from the site into that section. But what your view is that is basically only incentivised by people doing deliveries or with a specific purpose to go there who will be going there already. But alternatively, there is the potential for residents not to have to use the Simmonley Lane junction. They could turn left using the site access road and onto the A57 there.
Yes.
And then, obviously, concerns have been raised about use of the Simmonley Lane junction and its visibility. Have you got any views on its capacity and the extent to which its use, and whether there be any perceived benefits in respect of that option being available to residents?
I think I'll be honest here and say it's not something I've considered because it's not been a junction that we've ever contemplated putting traffic down. There is obviously traffic already using that junction from Adderley Place and from the Scouts. Indeed, there's a development just been approved. I think just approved. There was a church on that corner which has been demolished, and there's a development now approved. So I've not looked at it. I would sincerely hope that there's no visibility problem across that development site.
I did notice the cleared site when I was there, but wasn't necessarily something that I could I'd expect anyone to know too much about, given the council's not presenting the case. So
I think Mr. Hurrigan probably knows a bit more about the planning background if you need more.
Yes, it was just what struck me when the concerns have been raised about use of Simmonley Lane and its unsuitability for use by the development. The possibility that Adderley Place residents on the western section have an alternative to using that junction. Whether I should take that into account.
I think there is definitely betterment for those Adderley Place residents.
And then, moving on to my final topic, question. So the gradient access and accessibility for pedestrians. So again, anticipate Mr. Nicholas's evidence will address the gradient and access in more detail. However, the evidence in your proof refers to the established public right of way along Adderley Place as being available for pedestrians to reach the bus stops and walk towards Glossop, avoiding the steep section of access road. I just welcome your views on the interaction between any increased use of Adderley Place by pedestrians arising from the development and its alternative use by existing residents for means of access. We may have potentially covered some of it in terms of the access and egress from the western section, but I'm thinking more about that eastern section. We've already covered the issue of wheelchairs, etc.
Yeah, it's. I must have walked that. I don't know how many times. The traffic flow is very low. I've not been there when the Scouts have been active. I assume that's in the evening. I've not done a 7 o'clock visit or whatever time the Scouts are there, so wouldn't like to comment on that. But it's undoubtedly a very slow road. It's not well surfaced for vehicles to travel at high speed. I think as a pedestrian you can meander your way through and not have any difficulties, but it's certainly a slow road, so safety isn't an issue from vehicle speeds, and it's certainly wide enough to allow a vehicle to pass a pedestrian without difficulty.
There are passing places closer to the Scout Hut, am I correct in saying, or at least informal passing places where vehicles encountering in either direction might be able to pass each other?
Maybe. Again, because we're not increasing traffic, I take your point about increasing pedestrians, but for vehicles there is more likely to be a reduction in vehicles than anything. So I think the need for a passing place will be at worst the same as it is today, and more likely better than it is today.
Thank you. That's all the questions that I have. So I thank you very much for the evidence that you've given, and I'll reflect on what I've heard. And that does end the presentation of evidence today. Just a few housekeeping matters and cross checks. Just in terms of the we'll address the pending documents in the morning. I'm not going to necessarily summarise those unless the barristers wish me to do so. Are you happy?
No, I've got a note in red ink where there are outstanding promises.
Okay, so I'll leave those promises to you until the morning. Just in terms of the room availability, am I correct in saying we can leave some of the bigger items and that will be absolutely fine?
We'll arrange to have the door locked after we
Okay, and then finally is just on the car parking. So I'm to presume, and I took it as the presumption this morning, hence why I flagged it up, that by virtue of everyone adding their registration numbers onto the forms, it means that the hotel won't, or the landowner won't be issuing fines, etc. Should we all leave and not pay the charge? Okay, I will inquire at the desk, but I'll just make a. That assurance is fine. Yeah, I just don't want not only personally, but everybody else who's participating. Okay, that's fine. So we won't receive £700 fines in the post then.
Sir, I think probably we have to put our registration numbers in every day that we're here.
Yes, I appreciate that. So, thank you. Okay, the time is, unless there's anything else anyone wants to query now.
Would it be helpful just to have a review of the programme?
Yes.
We, as you have just indicated, have reached precisely where we wanted to reach today, which is good. My feeling tomorrow is that we might do better than the programme indicates.
Okay.
And therefore, and obviously the council is hoping that the inquiry will A, finish on time, but B, a little before on time, if at all possible. And I understand that we're going to be back here probably next Tuesday. But the big question is, do we need to be back here on Wednesday as well? If we could make some progress to avoid the need to be here on Wednesday, that would be a good thing so far as the council is concerned. So I'm just looking at tomorrow and wondering whether or not, for example, arboriculture or ecology might be available tomorrow, and then whether anything that we were planning to do on Tuesday might be available for Thursday, so like conditions on 1A6 and potentially even Mr. Hurrigan. I know that Mr. Heathcote's not available.
I think conditions in 106 is not possible until next week.
Okay.
Because of the extent of work I personally need to do to provide.
That's absolutely fine.
To provide my comments that will make those roundtables run more efficiently. So I don't think that's possible. I can put it to Mr. Barrett whether witnesses are available and could be on standby tomorrow. I would expect it's unlikely more than one extra witness will be possible.
That would be my view, sir. I'll well, yes, I know there's... yes, I will have a witness available on the bench, so to speak. Now we're talking about Euro games. So one of my witnesses will be... My ecological witness could be made available tomorrow if we make the progress that Learned Friend hopes, and I share his hope. And then on Thursday we will have our other witnesses shuffled forward, if that's suitable.
Yes, I do think we will need Thursday in some form.
Yes.
It just may be that it is not as much of the day as anticipated, and I'm quite content for witnesses to be on standby potentially for tomorrow. Obviously, we'll mention that in openings for people with statements who may wish to ask questions of the witness as well, to make sure that isn't causing problems for people who may be wanting to attend on Thursday specifically to ask a question of those particular
absolutely. I wasn't suggesting that we would try and do without any of the 3 days that we are planning to be here this week.
Yes.
What I'm looking to try and do is to see if we can do without Wednesday of next week. Now, my learned friend and I have already discussed closings, and we think that if it suits you, we will be in a position to close on Tuesday.
Yeah.
So long as there is enough time in the day on Tuesday, if you see what I mean.
Possible alternatives of virtual closings. I wouldn't want to exclude that at this stage, that we could if that's all that was left, to come back on the Wednesday to hear closings, as much as I'd like to think everybody will cherish my closing, it may be convenient to do it virtually.
I wouldn't have any particular objections to it being altered to virtual closings to lose a sitting day. I'll be clear that the reason the programme was done like that was to give the barristers the opportunity to prepare the closings. So I didn't want to force the closings into a window that would be extremely difficult and put too much pressure on.
That's very kind, and please do that again in the future, sir.
But I would be happy to take it virtually. The reason why I didn't suggest doing it virtually at that point was contingency point of view, but we are seemingly hitting time, and probably will be ahead of time.
And we know, and by Thursday, at whatever time, we are going to know precisely where we are.
Yes.
So I'm just flagging it for transparency's sake at this stage. I'm not asking you to make a decision, and I'm not suggesting that we will be able to do without Thursday this week, because I don't think we will.
No, I don't think it's possible.
No.
I think because of the arrangements of witnesses, it's not possible to squeeze that amount of witnesses into that particular time, and that's knowing the questions that I have at this particular point to ask. Fine. So, and notwithstanding any questions that the interested parties may have. So, we're very much on a proviso tomorrow in terms of bringing a witness forward. We will mention it as part of housekeeping first thing, and it will be dependent on whether there's anyone who can't attend who may. We may look at alternatives. For example, hearing the ecology witness if we can, but then still take statements from people on ecology if they were intending to ask questions and reflect on that. And then obviously it will be up to Mr. Barrett whether he wanted to recall his witness at that particular point to address anything that was raised.
So thinking out loud, I don't know, obviously, sir, your questions or what third-party local residents, objectors have to say, but it may be better to call Mr. Tavendale. I suspect ecology is a bit more controversial and may take longer time, and if we're putting 3 witnesses across the inquiry floor tomorrow, civil engineering, air quality, which remains controversial as we've heard today, it may be that Mr. Tavendale's a better substitute than ecology.
Maybe we take a sounding in the morning, because it may depend on the statements that interested parties may wish to raise, and those people may benefit them in terms of asking questions. So it may be the case of what we've heard beforehand. You then decide which witness to call at that particular point, and we just make it clear that we do have the ecology or the tree witness in reserve.
No, that sounds all very sensible. I'm just trying to be pragmatic, and as we had a few minutes before 5 o'clock today, I thought, well, now's as good a time as any to have a general programme discussion.
No, that's exactly fine. I'm not going to republish a revised version of the programme at this stage, because we don't know where we'll be tomorrow. But we will just float the idea as to that we have got witnesses in reserve to use that contingency time instead on Wednesday, should we get to the point where we've got enough time to do so before 5 o'clock. It may be the case that tomorrow does not quite go as anticipated, and we stick to the programme as it is, but at least we can have that option and we can float that first thing tomorrow. Okay.
That's great. Thanks very much, sir.
No problem. I thank you all for your contributions. It's 4:43 and the inquiry is adjourned until 10 a.m. tomorrow morning. Thank you.